Yes, Lordship. Yes. Lordship, I did mention item number 52 from supplementary Lordship hearing. Lordship,
Yes.
this matter was parted on Monday, Lordship. And there's an urgency because here the posting question, Lordship. The department is to send for requisition to the Public Service Commission for recruitment.
Okay, let us try after admission.
Lordship. Obliged.
Lordship, please allow me to move this unlisted item in the VPC 47 of 2024. I'm missing on behalf of the main council, Arun Kumar Baigyo. He is on the way from Silchar.
Hmm?
So he's on the way from Silchar. He's about to wait. I'm missing on his
Which
behalf.
one? Unlisted.
This one.
Oh.
I beg to mention item 13. I've received
13.
and for the state respondents.
Hmm.
In 3 weeks' time, will be given to file the counter affidavit.
Okay, you are Mr.
Mosam Nankumar.
Your first. Yes.
Kids, it's like kids.
Council for the petition of Mr. So, that state council has submitted that he has received instructions.
Yes.
Received the necessary instructions to file counter affidavit and has thus straight for how much time? 3 weeks time to file the same.
His Lordship, I beg to mention item number 7. Counter has been filed by the state respondent, so Your Lordship, I may be granted 4 weeks' time to file my reply.
Okay. MSR Archula gives granted counsel for the petitioners has paid for and is granted 4 weeks time.
Yes, Your Lordship.
4 weeks time to file affidavit in reply to the affidavit of opposition filed by the state respondents. It's the case of the police.
Obliged, my lord.
To mention item 28. Lordship, if this matter can be listed next week.
Next week.
Next week.
Next week is only 2 working days.
Any other day?
One.
Just I have some matter for number 2. So
Or 2 weeks then.
after 2 weeks.
Okay, who is for the petitioner?
For the petition.
MS
Council
counsel for the petitioner is present. Mr. Yangarwati. Granted Central Government Council for the respond number 1 has wait for listing of the cases after 2 weeks.
Lordship,
Cases after 2 weeks.
Lordship, I have the same prayer in item 33 and 42.
Item
33 and 42. The same council.
of same council.
Yes.
Same order. 33.
33 and 42. Much obliged.
Lordship, I beg to mention item number 35.
Yes.
We have not yet filed our additional affidavit. Since we do not appeal the document.
Additional. Mr. C.D. Rongsang. That is counsel for the petitioner has sought has paid for listing of the case of the weeks in order to file an additional affidavit to bring on record certain documents, certain relevant documents. MS Naholi Planet State Council. There is no objection to the secretary. This is the case after 2 weeks. interim order, fast track shall complete the next step of the scheme.
May it please, Your Lordship. Your Lordship, I beg to mention, hearing item number 34. Your Lordship, I put this matter be listed after 2 weeks.
On the prayer of Ms. for the petitioner. Which prayer is made with the consent of the council for the respondents. This is the case subject to this.
Your Lordship, I also beg to mention, item number 27 for orders.
Yes.
Here, Your Lordship, the service upon the respondent, private respondent number 7 is still awaited. So, Your Lordship, I may be allowed to take steps upon the private respondent by way of substituted notice, Your Lordship.
Then we wait.
Item number 32 of the hearing list. Your Lordship, let the matter come up after 3 weeks.
MS,
AIME.
AIME, Learned Junior Government Advocate,
Yes, Your Lordship.
for the square number 1 to 3. Yes, wait for listing of the case after 3 weeks. You have informed the other sides.
Yes, Your Lordship.
Okay, it is submitted by Mr. So, Mr.
No,
Mr.
Isoto, on behalf of
Isoto.
Mr. Takaki.
Learned Council, representing Mr. Takakichu, Learned Council for the petition. The page law is the case of the 3 weeks.
Your Lordship, similar prayer for item number 39.
Petitioner, we have
Yes, Your Lordship. Lordship.
39.
My lordship, please. Lordship, item number 8. Kindly grant 1 week of time since we are waiting for the affidavit which we sent to obtain the signature.
You are for the respondent,
Respondent letter.
Mr.
Is in
V. Jimomi,
lordship.
Learned Junior Government Advocate. As read for listing of the case after
1 week lordship.
1 week in order to file counter affidavit on behalf of the state respondents. As the prayer is made with the consent of petition.
May I
The
please,
praise
Lordship. Lordship, I beg to mention item number 31, hearing item 31. I pray that this matter be listed after 3 weeks.
You are for the petitioner,
For the petitioner, Lordship.
MS,
Gate Secretary, on behalf of City General.
MS, so and so, Learned Council. I pray on behalf of Mr. C.P. Jamil and Senior Council for the petitioner. For listing of the case after 3 weeks. As MS, who is the State Council. The praise of is the case of the 3 weeks.
Yes, Your Lordship. Lordship, I beg to mention item number 20. Your Lordship. Lordship, here I have received the counter filed by the state on the 18th, Your Lordship.
Hmm.
So if I may be granted 3 weeks time to file my reply, Your Lordship.
3 weeks.
Yes, Lordship.
MS,
You
V.
see no for the petitioner.
Council for a petition has paid for an standard change. Affidavit in fact, the affidavit of opposition filed by the state respondents. This is the case of the 3 weeks.
Obliged. Yes, Your Lordship. Lordship, I beg to mention item number 14 to 16.
Hmm.
On behalf of TIPA. The state is here to receive instructions, so kindly list this matter after 3 weeks.
You have received instructions.
Not
Lordship.
yet, Lordship.
Lordships, it will come up in the normal course, Lordship. I have some documents to place before this meeting.
Lordship, similar prayer with supplementary item number 49 to 50.
Same council.
Lordship.
Okay, same then.
And Lordship, I also like to mention item number TB1 on behalf of Super
20,
TB1.
21, I think somebody just made a prayer, 21. And which one?
Lordship, can it pass over for a day?
No. Then which item? Mention was made. 20. Okay, your prayer is in respect of
Worship, we can advance over for it.
which one?
Item number DD1.
20. Okay. The prayer of MS so and so, the case is passed for the day. Your Mr. Age of learned counsel for the petition.
Item number DD2 to DD6.
22 to 26.
Worship. The state is the receive instructions, so finally list is letter
Re-
after.
Received instructions.
Yet to receive instruction.
You are Mr.
Or similar.
Learned counsel for the petitioner is present separate order. MS
Peter on behalf of civil.
on behalf of so and so, Learned State Council has submitted that the necessary instructions to file counter affidavit are yet to be received and has prayed for listing of the case after 3 weeks in order to file counter affidavits. Surprise about list the case after 3 weeks. Same order in 22, 23, 24, 25, 26.
Okay, so, my lord, I beg to mention item number 3. That is matter will be said after 2 weeks, lordship.
After 2 weeks,
Lordship.
Mr.
W. Murphy, lordship.
On the prayer of Mr. W. Marhu, Learned counsel for the petitioners, come on, let the case be listed after 2 weeks.
Please, Lordship. Lordship, I beg to mention item number 4.
4.
Yes. Lordship, kindly grant me 2 weeks time to file my affidavit reply to the affidavit filed by the government.
Mr.
Mane Konyak.
Learned counsel for the petitioner has prayed for further 2 weeks time to file affidavit in reply to the affidavit in opposition filed by the state respondents, Mr. Ananga. Learned State Council and MS Lucini.
Yes, Lordship. For respondent number 6,
Learned counsel
Lordship,
for the respondent number 6.
I'll also be filing my counter within 2 weeks, Lordship. It's
MS Lucini. Learned counsel for the respondent number 6 has also prayed for is granted 2 weeks time to file counter affidavit on behalf of the respondent number 6. Post of Mr. Angan, the State Council is in attendance.
much obliged. Mention item number 9. Here, pleadings are completed, so let the matter be listed for admission hearing. After 3 weeks, Your Lordship.
On the for a petitioner. MS so and so. Learned Mr. L. Sankam, Learned counsel for the petitioner MS.
AIME.
AIME, Learned State Council have submitted that the exchange of readings is complete and the case be listed after 3 weeks. List the case accordingly after 3 weeks.
Lordship, I beg to mention item number 11.
You have received
Yes.
affidavit in opposition. You want to file reply.
Yes.
MS.
Counsel for petitioner, can you read it?
MS. Council appearing on behalf of MS. Mr. Council for the petition. Wait for 2 weeks time to file affidavit in reply to the affidavit in opposition filed by the state respondents MS so and so and State Council is in attendance.
I'd like to mention item 17 and 19. I'm reviewing the state here. I pray for 2 weeks time to obtain instruction and time.
MS 17, item 17. MS so and so learning council for the petition is present, Mr. Team Chair. Additionally,
Yes.
additional petition has prayed for and is granted 3 weeks time to obtain necessary instruction and to file counter affidavit on behalf of the state respondents. This is the case of Ships. 19, who is you are petitioner? Mr. Lorenzo Land Casablanca petitioner. Mr. So-and-so was paid for an incident at Ships. Right. 18 or 19? 19. Oh, all three. 19. 19. You are also in 18?
No. Only
18, who is the petitioner?
looks only 17 and 19.
For motion, item number 1.
Yes.
Please, your lordship.
Wasn't 24. I saw it yesterday. I saw it yesterday. It's 2021. No, it's 41. Long now. It is there. I have seen it. We have item 2, which are hand. Please looking for item 1.
Your lordship, I beg your pardon.
Brief of item number 1 is looking for brief of item number 1. We have item number 2. You are the counsel?
Yes, your
Item
lordship.
number 2.
Yes, yes.
In the meantime, you look for item number 1.
Yes, so both the cases are similarly situated, your lordship. In both the cases, the petitioner is praying for release of the pending bills, your lordship. For contract work that was successfully completed, your lordship.
Art MS
Reiterate.
V unit credit. Council for the petition. Mr. Intin petition for all the respondents. It is the case of the petitioner that by an work order dated 10/2/2014, the petitioner was awarded a contract for quote unquote for construction of open air theater with green room and toilet facility at Jakpang for a contract value of rupees 33.02 lakhs. According to the petitioner, the petitioner, after the work order, proceeded to execute the contract work and complete it. The contract work in the year 2017. A grievance of the petitioner is to the effect that out of the petition was only disbursed an advance amount of rupees 14 lakh 35,632 till date to stop, despite completion of the contract work as far back as in the year 2017. Seeking direction to the respondent authorities to disburse the outstanding amount of rupees 18 lakh 66,368. The petition has preferred the instant writ petition to establish notice returnable in 4 weeks as Mr. Chandler.
Lordship, may I please, Your Lordship? Since the issue pertains to non-payment of undisputed pending bill, Your Lordship, it is my humble prayer that a
Where is
shorter,
the question of undisputed?
Lordship, because even the technical team from the department has come and verified the,
You have quoted Tamsir. Have you gone through the entire judgment of Tamsir? You have quoted from Tamsir, is it not?
yes, Your Lordship,
In your repetition,
yes, Your Lordship.
paragraph 10. Have you gone through the entire judgment of Tamsir? Para by para, you have gone through.
Yes, Your Lordship.
Until there is an admission of liability from the head of the department. Otherwise, repetition of this kind is not maintainable. Law is clear.
Yes, Your Lordship.
Law is clear. This kind of repetition is not maintainable under 226. Unless there is an admission of liability. Where is the admission of liability? This photograph. The admission of liability should be from the head of the department. That is why you have to wait for the counter affidavit. If they say, then Tamsir only will be applicable. If they deny, repetition becomes not maintainable.
Yes, Your Lordship.
As soon as appeared and accepted notice on behalf of all the respondents, comma issuance of formal notice stands dispensed with. Students and a counsel for the petitioner shall furnish extra copies of the petition along with an access number to Mr. Inchen within 3 working days from today. Who is the first one? First one, you write. Paragraph 2. Construction of cafeteria at Chakhang. Completed in 2017?
Yes, Your Lordship.
Advance amount 11 lakh 6,111. Outstanding amount 20 lakh 81,889.
Yes, sir.
For motion from the supplementary cost list, item number 53. For admission, item number 5 and 6.
Please, Your Lordship.
Yes.
Lordship here, in the present case, Your Lordship, the petitioner is praying for authorization. And Your Lordship, this matter is a covered case, Your Lordship, covered by the decision of this honorable, the division bench of this honorable court, Your Lordship. Your Lordship, if I may be allowed to place the decision of this
No,
honorable.
first place your case. First place your case.
Yes, Your Lordship. Lordship, the petitioner was appointed in by order dated 23rd May 1984, Your Lordship. His appointment order is in page number 17, Your Lordship. The type copy is in page number 18, Your Lordship. If I may be allowed to, with the in the
Yes.
interest of public service, the following persons are hereby appointed as Project Kalasi in the scale of pay of 300 per month under the establishment of SDO PhD with effect from the date of joining to this post. This appointment is purely temporary and liable to be terminated at any time without any further notice shown. Your Lordship, the name of the petitioner is reflected in serial number 12, Your Lordship. So, Your Lordship.
Yesiru. Yesiru.
Yes, Your Lordship.
Yes.
So, Your Lordship, even though it is reflected in the appointment order as the scale of pay was to be paid to the petitioner, but his salary was on fixed pay, Your Lordship.
Okay.
Your Lordship, after serving the department for 5 years, Your Lordship, he was released by order dated 24th May 2019, Your Lordship. His release order is in page number 21. And the type copy is in page number 22, Your Lordship. Your Lordship, may I read the release order? As per
Yes.
C's order number so and so dated within 2nd January 2019, the following were charged employees under the Marine subdivision under E PhD division are hereby released on superannuation of 60 years of age and or retirement or completion of 35 years of services. Details shown below. The name of the petitioner is reflected in serial number 2.
Your case is 35 years.
Yes, Your Lordship, I have completed 35 years.
Yes.
Your Lordship, after I was released from service, Your Lordship, I've made a representation to the department, Your Lordship, to retrospectively regularize my service, Your Lordship. However, it was not considered so, Your Lordship, in which the petitioner has opposed this one.
That is annexers. Annexer 4A. What was your status at the time of release? Your scale pay or fixed pay?
Fixed pay, Your Lordship.
Fixed pay.
Yes, Your Lordship.
Your appointment order showed that your pay, scale of pay,
Yes, it was within a
oh,
scale of pay,
fixed,
Your Lordship.
fixed,
Yes, Your Lordship. However, my salary was fixed. pay.
fixed.
Yes, Your Lordship. And Your Lordship, the petitioner has to represent council file to RTIS, Your Lordship,
Hmm.
with regard to the scale of pay as well as to those employees who were granted scale of pay, as well as to those employees, work charge employees who were appointed on fixed pay and then regularized, Your Lordship. And the information to that RTI reply was, RTI information was made on 10/8/2021, Your Lordship, which is in page number 25, Your Lordship.
Their upgradation to scale of pay
Yes,
was subsequent to your release.
yes, Your Lordship.
Subsequent to your release.
Yes,
Your release date was 30/6/2019,
Yes, Your Lordship.
and this scale of pay order was 15/1/2020. Annex page 26 onwards, annex
Yes.
4. And what is the other one? Date of regular.
Yes, Your Lordship. 195 work charge employees were regularized, Your Lordship, and all of them were junior to me, Your Lordship, and
What is the scheme?
page number 49, Your Lordship, annexure 7.
This scheme is for enjoying those for those work charge employees
Yes, Your Lordship.
who enjoyed scale of pay and had completed 30 years of service
Yes, Your Lordship.
as on 1/1/2015. So for 30 years of service is concerned, I think you have completed.
Yes, Your Lordship.
But so far as scale of enjoying scale of pay, I
Yes,
think
Your
that element was absent.
Yes, Your Lordship. I was not granted scale of pay, Your Lordship.
What is the criteria?
Lordship, as of now, there is no policy or scheme for granting scale of pay to fixed pay employees, Your Lordship. And it is the discretion of the department, Your Lordship.
Discretion.
Yes, Your Lordship.
You retired, released as what? What is as labor?
Your charge Khalasi.
No, no. Voucher? No, no. Your release order says something. As labor. What is as labor? Your appointment was
I was appointed as worker. Your charge Khalasi.
work class. And why you are saying that your case is covered?
Because, Your Lordship, in a similarly situated case, Your Lordship.
This readable 35.
Yes, Your Lordship. In a similarly situated case, Your Lordship, this honorable court has given a direction to the state respondents to regularize the service of the weak petitioner, Your Lordship. And against the state decision, Your Lordship, the state has preferred an appeal which was dismissed by the division bench of this honorable court.
What is the observation regarding scale of pay in the readable judgment?
It is reflected in paragraph number 30, Your Lordship.
Paragraph
30, Your Lordship.
you file any representation
Yes, Your Lordship, I've made a
prior to
representation.
your release?
Yes, after I was released from service, Your Lordship, I've made a
After,
representation. Yes, Your
I
Lordship.
am asking whether prior to your release.
Your Lordship, verbal request was made before the department while I was in service, Your Lordship. But despite the verbal assurances, nothing positive materialized, Your Lordship, while I was in service. Your Lordship, from the RTI replies, Your Lordship, can be ascertained that scale of pay is awarded by adopting a pick and choose policy, Your Lordship.
Is there any document regarding this grant of scale of pay? What is the criteria? And how you are giving?
In fact,
380 persons were granted scale of pay. Then I have checked all these 380 persons were junior to this petition. Then that is discrimination on the face of the record. If these 380 persons, if I check their date of joining service, then it is between 1986 to 1988. All these 380, they were granted scale of pay on 15/1/2020. But the petitioner who retired earlier, he was not granted. Now, whether that will change the situation.
Regarding this, Your Lordship, we have made it clear at there are 5 of our. And kindly turn to page 3 of my activity notice.
Para
Para 5. Sakura A, Your Lordship, married, Your Lordship.
Para 5.
Yes, Your Lordship, para 5.
Response number 1, 2, 3, 4.
Yes, Your Lordship.
And what is the case of the petitioner in the writ appeal? He also retired from service, released from service on 30/9/2019. The respondent in writ appeal number 35 of 2022. This writ appeal,
Yes, Your Lordship.
writ appeal judgment, the 35 of 2022. You have a copy or not?
Your Lordship, I don't have that copy. Your Lordship.
That pen is almost similarly situated like the petitioner here.
Yes, that, Your Lordship, the fact is different, Your Lordship, here. In this case, in this umpire case, they have approached the authority while they were in service. Whereas here, the present petitioner, he has represented only after he was released from service, Your Lordship. So, Your Lordship, In fact,
Approaching or not approaching?
Your Lordship,
Approaching or not approaching?
Your Lordship.
How does it make a difference when you are not granting him scale of pay? If you adopt a decision, it should be similar, identical. No one should be discriminated. You have to follow the principle of Article 40. Now, just because he has not represented, suppose, you deny him. That is not the principle available to the state as a model employer of a welfare state. Suppose just because it is to be given to all, similarly situated, identically situated. Now here you have on 15/1/2020, you suddenly decided to grant scale of pay to 380 persons. And with the observation that the fixed pay employees who has retired on or before 1st January 2020 shall not have the right to claim scale of pay. Now, what did the single judge then in the other case observe? Let us see. Even without asking the state as a model employer and under a democratic form of government and being a welfare state should have done it. Having not done so amounts to exploiting its own citizen for 35 years and releasing them with empty-handed. Now, did you appeal against this judge?
Your Lordship, regarding which?
35, readable 35.
Read Appeal 35, yes, Your Lordship. We have filed an appeal, but if that was dismissed again, we are contemplating to file before the appeal is heard. So
We have a copy of the
that,
dismissal.
that I don't have to do.
You know,
But Your Lordship,
yes, madam.
yes, Your Lordship,
You know, SLP dismissal order
dismiss.
against 35.
No, that was before the division bench, Your Lordship.
No, that is readable 35 of 2022.
Your Lordship.
Against that, have you preferred any SLP?
That, Your Lordship, I've been informed, Your Lordship, that SMP has been filed.
The confirmation.
Lordship.
if there is any stay, suppose, then this judgment will not operate till the time SLP is decided, right? If there is any interim order staying the operation of this judgment, then it may not be covered case as on date. But if there is no stay or no SLP is prepared, then this judgment will hold the appeal. This judgment will hold the appeal, right? And in that case, a single judge, single bench, is bound by the order of the division bench. Have you got my point? So, if you have preferred any SLP and you have got any restraint order or stay order, then this may not be holding the field till the SLP is decided. But if there is no stay operating, then it is a different case altogether. No SLP is preferred. This is an information only, not a case where you are required to obtain documents. It's an information. If your case is covered, then if this otherwise this court is bound by the judgment of the division bench. Slight distinction in facts that he did not represent at the time when he was in service. But single judge in that case also observed, like I said, even without asking the state as a model employer and under a democratic form of government and being a welfare state should have done it. Having not done so amounts to exploiting its own citizen for 35 years and releasing him empty-handed. So even without asking, he should have done it. That is the court observation of the single judge. So this man did not do so. Just because he did not do so, it is not open for you to leave him aside. When your junior there, his juniors were given. Let us see once again the annexes. These 380 persons. There is no rational formula, perhaps you have applied. Huh?
That's what your lordship, the department has been specific, what's the order? And given that it's-
Can you get the information? Did you prefer any SLP against this one? Read appeal number 35 of 2022. Just get the information.
After every your lordship.
We have seen it. Maybe on Monday. Monday. Just shall I record? Get the information. Yes.
Tuesday, your lordship. Let it be
Tuesday will be not Tuesday,
Monday,
Tuesday,
yeah,
Tuesday,
Tuesday.
Tuesday. Monday is holiday perhaps. Yes, madam.
Lordship, what about tomorrow?
Tuesday, Tuesday. Tuesday. Third MS
Reasonable.
V
Okay.
Ferry. Learned counsel for the petition of an MS S Mary. Senior government for the all the respondents you were
Lily Su, standing on behalf of my senior counsel, Joshua Cheki, respondent number 580.
okay, yes, Mary for the addition,
Respondent 1 to 4.
senior government advocate. Senior government advocate or
Lordship,
additional senior government advocate for the respondent number 1, 2, 4 and MS
Respondent number 5, K. Lily Su.
learned counsel appearing on behalf of Mr. J. Sheki,
Lordship.
learned standing counsel, accountant general, Nagaland, for the respondent number 5. On the request of Ms. S. Mary, learned senior government advocate. Please that case says on Tuesday for the purpose of obtaining instructions. As regards read appeal number 55. Tuesday.
For motion from the supplementary cost list, item number 53. WPC 47 of 2024.
What is the urgency here? What kind of urgency?
Urgency is, sir. Surprisingly, at the premature stage, have superannuated on retirement from the service. So for reinstatement,
Mr. Counsel, what kind of urgency to challenge an order dated 2/8/2021?
sir,
You explain me first.
so my.
What is the, why a privilege is not given for moving an unlisted motion? In case of extreme urgency, is it not?
Yes, sir.
Now, you are challenging an order dated 2/8/2021
Yes, sir.
after 2.5 years.
Yes, sir.
Tell me, what is the urgency?
Sir, after receiving this impugn order,
Where is that impugn order?
to- to- to-
Page. Page 30. What is this? On attaining the age of superannuation. Deepak Sarkar Jamadar working under FCI
Yes, sir.
is have retired from service of FCI
Yes, sir.
in the afternoon of 37/2021.
Yes, sir.
So what kind of challenge you are making to this order?
So, my service period is still remaining 7 years. At the premature stage, he has issued this impugn order stating that I retired from service of FCI in the afternoon 13/7/2021. But my 7 years is remaining. So at the premature stage, he has supervised me on retirement on attaining 60 years, but not attaining the 60 years. Actually. It was only 53 years. So this is my taking shelter of the
Taking shelter is one thing. Moving an unlisted motion is another. This particular privilege is there for moving any petition or any other petition
Sir.
in case of extreme urgency.
Yes, sir.
If it is not extreme urgency, in fact, this petition is liable to be dismissed on the grounds of delay, prima facie. So there is absolutely no urgency. The challenge you have made against an order which was passed on 2/8/2021.
Yes, sir.
We are in March 2024.
Yes, sir. So,
Don't abuse the process of the court.
sir, within this period, we pursue to them.
Without questioning the learned counsel who sought for unlisted motion, I thought that it is a case of extreme urgency. I granted it without questioning it.
Sir,
That does not give you a license to move any unlisted motion.
So we, as soon as we receive the this impugn order, we pass it to the department.
Mr. Counsel, you are not addressing my point. Your agency will not do. Your agency as a council will not permit you to move an unlisted motion. It is the urgency of the petition client. Don't try to abuse the process of the court ever. What is your name?
My name is Arun Kumar Gupta.
You are from which place?
Silchar.
Just because you have arrived in Kohima today from Silchar, so that is the urgency. This is too much. Let us see your appointment order. According to you now, tell me, what is your date of birth?
Date of birth is 24/7,
24/7.
1968.
That is disclosed. That is disclosed. What is your case about? What is your case exactly?
1968 date of birth.
1968 is your date of birth.
So my date of retirement of 28. No, 31/7, 2020.
2000.
I'm attaining 60 years. I'm attaining 60 years.
Now, what was the date of birth incorporated in your service records?
In the service record, my date of birth is 24.
Where from you are saying that 24/7 1968 was incorporated in your service records? Please. Page 35. Page 35. 68. Where is the impugn order? Is So did you represent thereafter?
Yes, sir.
Did you submit any
Yes, sir.
representation? Then what is the reply?
Given any response till date.
And what according to you is the age of superannuation? Hmm. Hmm. Is there any police case?
But there are no any police case.
Hmm? Some FIR was lodged against you?
Sir, no FIR
Hmm.
not against me. When on receipt of this interim order, I proceed to the department. I see my records, how I will do. They did not give any response. In spite of that, they and FIR against. But during my service life, no, no. But again, this I take it from where I asked for opinion. Again, they did not give any reply to me, but they have furnished an FIR to the local police station. But that FIR to be also not
You are appointed in which office? Nagaland office?
that still do not.
Nagaland.
Yes.
And you were released by
FCI regional office GM in charge, regional office Dimapur. GM in charge is not competent. to give supervision. He is only assigned the job of looking after day-to-day work of the department as in charge.
Heard Mr. A.K. Baju. Learned Council for a petition. The petitioner has instituted the instant rate petition under Article 26 of the Constitution. We are saying an order dated 2/8/2021, an office order dated 2/8/2021 passed by the respondent number 3, whereby, the petitioner stood retired from the service of the respondent Food Corporation of India in the afternoon of 30/7/2021. Petitioner was then working as Jamadar in the regional office of the FCI at Dimapur within bracket Nagaland region, to retire from service of the Food Corporation of India in the afternoon of 30/7/2021 on the ground that the petitioner had, on the purported ground that the petitioner had reached the age of superannuation. It is the case of the petitioner that, as per the petitioner was initially appointed on version 2 and office order dated 30/8/1988, and as per the service records, his date of birth was is 24/7/1968. According to the petitioner, the age of superannuation from the service of the FCI is 60 years. And as such, the petitioner ought to have retired on reaching the age of superannuation only in the year 2028. Issue notice returnable for its the petitioner subject states for service of notice upon the respondents. The year 2028, that's all. The petition issue notice returnable. Issue notice returnable in 4 weeks. The petitioners have text states for service of notice upon the respondents by way of registered post, which AD within 3 working days from today. Mr. Poitu, Land Council for the petitioner has insisted for interim relief in the form of stay of the impugned order dated 2/8/2021. The petition is moved as an unlisted motion expressing urgency And accordingly, permission was granted. The impin order dated, the repetition is moved after passing of, after elapse of 2.5 years from the date of passing of the impin order on 2/8/2021. And as such, this court is not inclined to pass any interim order staying the operation of the order dated 2/8/2021. The matter of delay and laches in filing a petition is left for consideration at the appropriate time.
For admission, item number 10.
Yes.
I have been excommunicated from my village, my native village, for political reasons. I contested elections last year, Lordship, that is 2023 general elections to the Nagaland Legislative Assembly from JDU party. Now, there was another person, Lordship, from my village, the same village, Lordship. He had his declaration with the full cooperation of the village council of my village, Lordship, whom I have also included as respondent number 4 in this instant petition. They were the ones who excommunicated me. So, a declaration program for the other candidate, Lordship, was held on 6th of February 2023. I have also annexed the declaration program in my affidavit reply at annexure 5, page 12, Lordship. Now, where the respondent number 4, it's clearly written in the program, gave the welcome address. The welcome address of the persons who have all participated in that program. The respondent number 4, that is the village council, they gave the welcome address. And not only that, in the election process, entire election process, they sort of, in many ways, facilitated the other candidate, Lordship. But be that as it may, Lordship, me also being a native of that same village, I also wrote a letter to the village council, that is the respondent number 4, on 15th of February 2023, requesting the council that I may also be allowed to have a declaration program in the village, similar to the other person.
What is declaration program?
Declaration in the sense, Lordship, declaring to the public that I am contesting as a candidate from that political party.
Is there any right? Is there any right that you can claim that I should also be declared?
Lordship, I am not on that, Lordship. I am not on that, Lordship. It's just that, Lordship, since this that similar
He was given the opportunity, I should also be given the opportunity.
Yes,
So to claim that, you have to have some right.
Lordship. Now, Lordship, that is not the issue in this case, Lordship. Whether I was allowed to have declaration or not, that is not the issue in this case. merely trying to narrate the facts, Lordship, and how the respondent number 4 has acted in a partisan manner. Now, Lordship, instead of that, Lordship, instead of allowing my declaration, Lordship,
What is respondent number 5-2?
they are the village council members, Lordship, who have excommunicated me.
No, who has respondent number 4 has excommunicated
Yes,
you?
yes. Now, this is a covered matter, Lordship, in fact.
Okay, we'll come to the cover matter later on. Why we start saying covered matter? First, let us
Lordship,
have a grasp of the facts.
Yes, Lordship.
Yes, then Sungtia Village Council.
Yes, Lordship.
Okay. Where is the order excommunicator?
Annexure 4.
Page?
To the writ petition, Lordship. Page 43. Page 44 is the translated copy. This was issued in the month of July 2023, Lordship. But prior to that, Lordship, another letter was.
I have not understood page 44. What is this? Sungtia, 1 minute. Sungtia, Madam Putu Meden. What
Yes.
does it mean? Sungtia, Madam
Yes, it means the
Sanger
village council, Lordship.
Putu Meden.
Yes.
It is
the
village council.
Yes, yes, Lordship. I may be allowed to read, Lordship. The Chongtia Matamjangar Putumenden on this the 30th day of June 2023 through its meeting decides as follows. Mr. So-and-so for acting in contravention of the Chongtia village customary practices is from this 30th day of June 2023 excommunicated from Chongtia citizenship for his lifetime. It is further informed that any household that harbors welcomes him within Chongtia village shall be locked. Each representative from all 14 clans under Matamjangar Putu Menden append their signature respectively.
Who represents respondent number 4?
For all the
You-
other respondents.
You admit this?
Yes.
You admit this?
Yes.
Issuing about this?
Yes, sir.
Now, Lordship, this was issued in the month of July 2023, Lordship. But in the month of February, Lordship, when I asked for
What is the date of this order?
2/7/2023,
2/7/2023.
yes, Lordship.
It is published in newspaper or what?
Yes, it was published.
Huh?
Yes, it was published in the newspaper on 2nd July 2023.
Okay. What is the act governing this village council?
Yes. It is in
Let us see.
Nagaland Code Volume 3.
Huh?
The powers and functions of the village council is clearly mentioned in Section 12 of the Act,
Act is of the year, which year?
1978, Lordship.
1978.
78. Yes, Lordship.
What is the name of the act? Okay. 61. So members are chosen by villagers.
Yes, Lordship.
Hmm?
Yes, Lordship. Within the village,
Only.
Then
the-
it is to be approved by the state government.
Yes, Lordship.
Okay.
The deputy commissioner is the appointing authority of each district. We have implemented the deputy commissioner of the concerned district, Lordship, that is Mokokchung, as respondent number 3 in the instant writ petition.
It is in our area or what?
Yes, Lordship.
Our area.
Yes, Lordship.
So that is why it is put to men then.
Yes, Lordship.
Okay. Yes, you were saying about power and duties.
Yes.
Okay.
Section 12, Lordship.
Okay.
If I may be allowed to read, Lordship.
Yes.
Section 12, subclause 1. The village council shall have the following powers and duties. 1. To formulate village development schemes, to supervise proper maintenance of water supply, roads, forests, sanitation, education, and other welfare activities. 2. To help various government agencies in carrying out development works in the village. 3. To take development works on its own initiative or on request by the government. 4. To borrow money from the government, banks, or financial institutions for application in the development and welfare work of the village and to repay the same with or without interest as the case may be. 5. To apply for and receive grant and net donations, subsidies from the government or any agencies. 6. To provide security for due repayment of loan received by any permanent resident of the villages from the government, bank, or financial institution. 7. To lend money from its fund to deserving permanent residents of the village and to obtain repayment thereof with or without interest. 8. To forfeit the security of the individual borrower on his default in repayment of loan advanced to him or on his commission of a breach of any of the terms of loan agreement entered into by him with the council and to dispose of such security by public auction or by private sale. 9. To enter into any loan agreement with the government, bank, and financial institutions or a permanent resident of the village. 10. To realize registration fees for each litigation within its jurisdiction. 11. To raise funds for utility
These
service.
are all development works.
Yes, Lordship.
Now, what is administration of justice?
Lordship.
Section, I don't know about section 13. Section 13 has gone missing in this book. Section 13 has gone missing from this book.
Lordship.
Do you have section 13? Any section 13? Do you have any section 13?
I'll get another book, Lordship.
In this book, section 13 is not available.
Since I've reproduced the relevant portion in my petition, I did not put the book. But
Section 14 is there. Administration of justice.
Now, in the entire Act, Lordship, there is no authority vested on the village council to excommunicate anyone. For political purposes, for customary purposes, or for any other issue.
Let's.
Lordship, section 13 is regarding power to do certain acts in the event of an epidemic.
Okay. Okay, okay, okay.
But
Are you sure?
yes, Lordship, my learned finance has also another copy, Lordship. They are also same thing, section 13.
See, if you read section 12,
Yes,
then within bracket 1, 2, 3, 4, 5, 6, 7,
Yes,
8,
Lordship.
9, 10, 11, 12, 13.
yes. But here also, Lordship, 12, and then there is no 13 in this book as well. In mine also same thing. So that must be
But
section
no,
13.
because if you read down, maybe you are correct. Maybe you are correct. But book is misleading. Eh, oh, it is. Wait a Yes. Let us read section 14 also.
Fourteen one. The village council constituted under the law in force from time to time shall administer justice within the village limits in accordance with the customary law and usages as accepted by the canons of justice established in Nagaland and the law in this respect as enforced from time to time. In case of disputes between villages falling in different areas of districts, two or more village councils may settle a dispute in a joint session or refer it to the appropriate authority. 15. 1. The village council shall be the auxiliary to the administration and shall have full powers to deal with internal administration of the village. A. Maintenance
Now,
of
is there, suppose this is an order passed, is there any appellate provision? No. You want to say that this is without jurisdiction.
yes, Lordship.
You want to say that
Yes, Lordship.
they suffer from lack of jurisdiction,
Yes,
lack of
Lordship.
authority, lack of
Yes,
power.
Lordship.
It is your case.
Yes, exactly.
And what is the reply given by the village council?
They are saying that I was excommunicated, not for political reasons, but because on 30 July, 30 June 2023, a meeting was held in the village, which was to be attended by all the citizens of my village. So in that, the police came, Lordship. Now they are blaming me for the appearance of the police on that particular day in my village. Now there is not a single evidence, Lordship, that I summoned the police.
And 9 and 10.
There are 9 and 10.
Replied, Lordship.
Let me read, then I'll go to your.
Lordship. Are you allowed to read?
No, Lordship, 7, 8.
Huh?
Start from 7.
7.
Page 6, Lordship, to the capital office.
7.
Am I allowed to read, Lordship? That with regard to the agreements made in paragraph 5 of the writ petition, this deponent begged to state that as per the customary practices, the village/village council normally held general meeting twice in a year. Accordingly, the half-yearly village council meeting was fixed on 30/6/2023 to discuss various issues pertaining to the village. In such meetings,
Order is also 36, 2023.
it was
order.
published, yes.
Huh?
Order is also 36/2023, and it was published in the newspaper on 2nd July 2023.
Okay.
In such meetings, it is the customary practices that no outsiders are allowed within the village in as much as various internal issues are required to be discussed in such meetings. Unfortunately, on that day when the meeting was about to commence, 20 police personnel entered into the respondent number 4 village without any prior information to the village council. It is stated herein that there is no law and order problem in the village on 30/6/2023, so as to depute police personnel by the administration. On inquiry by the village council as to why the police personnel has been deputed during the village council meeting, it has been informed that it was on the instigation of the writ petitioner to the district administration. The police personnel were deputed to the village council meeting. It was unknown to the customary practices of to held village council meeting under the security of police personnel when there is no law and order problem within the village. Therefore, the village council took a serious note of the inaction of the writ petitioner interfering with the customary practices of the village, and accordingly, the village council have taken a decision on 36/2023 to excommunicate the writ petitioner from the citizenship of Chongtia village. The Chongtia village is a traditionally established village, having its own custom and usages for functioning of its village. Apart from the powers and functions of the village council provided under the statute, that is the Nagaland Village Council Act 1978, the village institution of Chongtia village as Mitum Jangar Putu Mitum having its own unwritten customary law and usage which is followed since time immemorial. The decision taken on 36/2023 by the Chongtia Mitum Jangar Putu Mitum has been done as per their custom in view of interfering with the customary practices of the village by the writ petitioner. Therefore, no illegalities has ever been committed by the Chongtia Mitum Jangar Putu Mitum by issuing the impugned order dated 36/2023. It is pertinent to mention herein that the respondent number 4, immediately on noticing the deployment of the village personnel without the knowledge of the village council, lodged a complaint dated 36/2023 to the Deputy Commissioner Mahupchong, requesting him to withdraw the security forces from the village immediately in order to conduct the meeting peacefully and to ensure peace and tranquility to the general public at the village. Paragraph 8. That the agreements made in paragraph 6 of the writ petition is not correct and denied by this deponent. It is stated that the impugned order by which the petitioner was excommunicated does not have any connection with the election or the political matter. As stated, the village council having found that the writ petitioner have acted in contravention against the customary practices and usages, a decision was taken by the impugned order dated 36/2023. It is categorically denied that the impugned order dated 36/2023 was issued without any reason.
Yes.
Now, Lordship, with this, I have replied in my affidavit reply.
What is this government stand?
Your Lordship, here the state is just a performer.
Lordship, state is not performer here. They are proper respondents.
Now, impugned order is passed by the respondent number 4.
Yes, yes, Lordship.
Let us first concentrate
Yes,
on
yes.
that. Whether if it suffers from lack of authority and jurisdiction,
Yes,
it goes.
yes, Lordship. My lord is right.
Now, what you have written? Are you admitting that you have brought the police?
No,
No.
no, Lordship. And Lordship,
Then what is their basis?
Lordship,
Is there any bar of police making making a visit to a village?
no, no, Lordship. And Lordship,
If police is not able to enter into any village, there could be two situations.
yes,
Police may be informed by the petitioner,
yes,
or police, because it is entrusted with the law and duty, it can on its own, having received inputs, intelligent inputs, can make a visit. Either of the two situations. Now, what is the basis of forming an opinion, of reaching a conclusion that it was the petitioner who had brought the case? Is there any basis?
there is no basis.
Only
at all.
paragraph 7 and
Yes,
8.
Lordship. That is all. They have not accused any evidence,
Hmm.
neither the private respondents nor the state respondents, Lordship. Now, Lordship, I have narrated certain circumstances in paragraph 4 of my writ petition. I believe it was because of these earlier circumstances that the police themselves, Lordship.
They are
felt it
entrusted
necessary.
with the administration of justice also.
Yes, Lordship.
Huh? Now tell me, what is your covered case?
Now, Lordship, I may be allowed to read paragraph 4 of my writ petition.
Read petition.
Yes, Lordship. Why I believe the police felt it necessary, perhaps, Lordship, to come to that village on 30/6/2023.
They are not saying they are simply saying it is the petitioner perhaps. Is it not?
Lordship,
Paragraph
I mean,
4.
yes. That the petitioner, that thereafter the petitioner contested as an intending candidate from JTU party from 20th Kurudang Assembly constituency in the general elections to the 14th Nagaland Legislative Assembly held on 20th/2/2023 and was the unreturned candidate. Though the petitioner is not alleging the respondent number 4, yet in order not to suppress facts from this honorable court, it is stated that in the course of election process, his father-in-law's house, where he was stationed for elections candidature nomination at Salongtam Ward, Mohokchung, was attacked on the night of 6/2/2023 by unidentified persons, during which 2 residents of the house were injured. A FIR was filed in relation to the incident by the petitioner before the officer in charge, PS1 Mohokchung, relevant part of which is reproduced as under. On 6/2/2023 at around 10:30 to 11 p.m., some people numbering around 10 of Chongja village came to my father-in-law's house and assaulted 2 persons severely who were present at the house. They also ransacked and damaged the house. This created fear and psychosis in the mind and life-threatening to me and my family members. Therefore, I immediately urge your esteemed office to kindly nab the above referred culprit at the earliest. This news was also published in the local dailies, Lordship, the next day.
Okay.
I
Yes.
have annexed the newspaper publication
Hmm.
item. At annexure 2P, page 30.
Yes.
Mr. Mirror, Nagaland election
Hmm.
2023, miscreants ransack house in Mohokchung. So, in the suspected case of election-related violence, unidentified miscreants ransacked a house and injured 2 persons in Mohokchung town late Monday night. So, they have given the details in the
Okay.
interview setting. If I may continue,
Yes, please.
reading up paragraph 4. Thereafter, on 15/2/2023, petitioner wrote a letter to the.
Yes, yes.
Now, Lordship, I may be allowed to read from paragraph, from page 10 of the same paragraph, Lordship.
Page 8.
Page 10, page 10.
10.
Yes, ma'am.
Yes.
Subsequently, on 21/2/2023, one of his supporters, that is the petitioner's supporter, was badly beaten up and killed. The corpse was found in a forested site between New Camp and Satyar Mohokchung the next day. The victim was one Ngongchiba Kichu, aged 34 years, a mechanical engineering graduate. In this regard, a police case number TR34 2023 in connection with Mohopchong PS2, case number 0012-2023 under sections 120B, 341, 365, and 302 IPC was registered. And trial is presently going on against 9 accused persons before the Learned District and Sessions Judge. These people are still under custody, Lordship. Bail was also denied by this honorable court, Lordship.
Okay.
So maybe because of the existence of this earlier circumstances, Lordship, perhaps the police felt, the administration or the police felt it necessary that on that day, if any untoward incident happened, as a precautionary measure, maybe perhaps they were deployed. But Lordship, it is categorically denied that I did not call the.
Where from Mr. Jamir, Village Council derives the power of excommunicator? Any power?
Kindly come to section 6 of the Act. Section 6. And last supper, Lordship. Provided that a member of chosen to fill in a casual vacancy shall hold office for the remainder, the term of office of the member whom he replaces. Next,
Yes.
Lordship. Provided further that village institution which were traditionally established like the Buddha Mandate in our area and recognized as village council shall continue to function as village council according to respective custom and usage. Lordship.
Yes.
So the Tunda Village Council is one of the council in our area, Lordship. We have unwritten customary laws, Lordship, which is been followed since time immemorial. There is no such foreign function for its communication, non-communication, Lordship in the Act. So the village council acted in accordance with the unwritten customary law, which I have stated at paragraph 7.
You don't have to require the, you don't have to follow the principles of natural justice also.
Lordship,
Is it not there in the custom?
Lordship, I've justified my.
I have read
Action.
paragraph 7 and
No,
8.
I've endorsed one documents also, the minutes. How the village council arrived to a
Just
decision.
because suppose there is nothing unwritten,
Yes.
unwritten, you say everything can be unwritten according to your whims and desire and whatever. Everything can be unwritten custom. There is no limit to it as regards unwritten custom. If the members decide this is custom, then this is custom. As if now, even if assuming for a moment, it is your custom, bringing the police to the village, it was in that custom. I don't know, in the custom, anywhere, any place, word of police is there. Right?
Yes.
Now, taking everything as correct for the purpose of argument, is it also in the custom that no principle of nature justice is to be followed? Tell me. That before imposing any penalty, that too for life, is it not the requirement of the principle of nature justice as per your unwritten custom? Please answer to me.
And secondly, Lordship, why?
That at least he should be put on
Correct, Lordship.
trial.
I agree, Lordship.
He should be put on trial at least. That yes, you have brought this police when the village council meeting was scheduled, and that has brought disharmony, distrust, whatever, so and so, so and so. You should explain as to why you should not be visited with a punishment.
Yes, law is civil lordship with regard to municipal justice.
Even if I think customary law, let us see, customary law, principle of mutual justice is there or not. Because I am not very accustomed with customary practice. This is why I am asking whether the principle of natural justice, all said and done, everything is written, everything is not written, right?
That is well settled. I have
But-
nothing to say. Lordship, may kindly consider one speak. Why the impugned order was passed by the village council respondent number 4. Kindly come to the minutes, page 24 of my affidavit. Lordship. It is not only on the ground of bringing the police personnel, Lordship. Kindly.
Whether
my
that,
affidavit.
that is ex parte perhaps, ex parte, that order is ex parte, is it not?
Page
Good
24,
page.
Page 24 of my affidavit, Lordship. Last page. This is the minutes of half yearly review meeting of Chungja Meeting Shangaputu Mental Health on 30 June 2023. This is a translate copy, Lordship, which is the original one. Lordship, may kindly come to para 6. This is the reason taken by the village council. The meeting resolved to expel Mr. T. Chalokompa from citizenship of Chungja village for life due to the following reasons. A. On 30 June 2023, he sent police personnel to cause inconvenience to the meeting of Chungja Meeting Changaputu. Second is important, Lordship. On then March 2023, Mr. T. Chalokompa, that is the petitioner, Lordship, enjoined the Deputy Commissioner Mohokchung to dissolve the village council, stating various invalidated evidence and notice allegation. Being a citizen of Chungja village, defaming the modifying the village council, which is the ultimate authority of the village, is treachery of highest order. Therefore, effective from Dodi taking his malicious intent into consideration, he is expelled from the village and will no longer be deemed a citizen of Chungja. I have nothing much to say about the conduct of the great petitioner, Lordship. But the reason is that here in our minutes speak for itself, Lordship.
But second ground,
Yes, Lordship.
writing to the deputy commissioner.
To dissolve the village council, Lordship.
Ah.
I don't know. Why have taken such a step against the village council? All this things are-
Everybody, if you read a newspaper and in the assembly or everybody, every political leader, dissolve this government. Dissolve this government. You come up with statements of opposition leaders every day in the newspaper. They have done this, this government has done this government has done this. This government should be thrown out. Just for making a statement or making an allegation. One statutorily constituted body cannot be thrown out or cannot be dissolved unless there is evidence on which how it is to be dissolved. Let us see.
Lordship.
Let us see.
Your Lordship,
By just an inhabitant making an allegation, is it the requirement?
No, Lordship.
How it is dissolved? How a council is to be dissolved?
Dissolve village council.
Otherwise 5 years. Otherwise 5 years. Is it not?
No, Lordship, there's no.
6A. Why not? I have read already. 6A
The Village Council members otherwise resolved by the state parliament
shall continue. Then
Shall
read,
continue.
read further.
for 5 years from the date of appointment. Provided that said period may be.
So making an allegation before the deputy commissioner will not do. It is the state government who can resolve.
Yes.
First thing, this ground, making a complaint, he is making a complaint and a wrong for gone. Bringing defamation. Then I think he should be provided with the opportunity to explain his situation. Yes, what is your cover case?
103,409.
By Justice N. Koteshwar Singh. By
Yes,
Justice N.
yes.
Koteshwar Singh.
Same, then Koteshwar Singh's judgment. I believe my Lord is aware of.
Remotely.
He has discussed elaborately, Lordship, regarding excommunication, its inception in different civilizations and practices. At paragraph 89, Lordship.
Paragraph 89.
Yes, Lordship. If I may read. Thus, as evident from above, statutory law does not recognize any form of punishment of excommunication or banishment, even for offenses involving customary laws. The issue raised in this petition is whether such mode of punishment will be permissible by any body or entity in purported exercise of enforcing customary laws. The answer of this court is in the negative, in the light of the discussions above referred.
Where did we discuss about this village council?
Paragraph 24, 24. Also, paragraph 86 shall also be important. And 87.
Yes, anything?
So for us, the MBO order date 36. His Council Lordship. I've stated in my paragraph 6 and 7. More than that, I have nothing much to say. There are two MBO orders, Lordship. I'm referring to the second MBO order, Lordship. When you come to page prayer of the writ petitioner, Lordship.
Page?
Prayer of the writ petition.
Prayer of the
Page 18. Lordship, got it?
60, Annexure 3.
Annexures.
Annexure 3 is what?
Annexure 3 by Lordship,
Page?
I was depart from my village temporarily,
Yes,
and
Lordship.
by Annexure 4, I was
Where is the
permanently.
page
Page
depart?
35.
Page 20,
35.
35.
36 is the translated copy.
36.
This,
Due to prior, cannot
this is the translation made by the writ petitioner, Lordship.
temporarily debarring, is it correct or not?
Temporarily debarring you from being part of Julian. This is wrongly translated. The writ petitioner placed wrong facts before the son of court. This facts is reflected. Lordship, can you turn to my affidavit?
No, just 1 minute. This, are you saying this page 36 is wrongly translated?
That is my first point.
First point.
Against this, Lordship, the petitioner approached the deputy commissioner.
Okay. Temporarily debarring. Temporarily debarring, this translation, tell me what is your correct translation?
Lordship,
As per you,
can you come to page 14 of my affidavit?
14.
Yes, my affidavit. So against this environmental lordship, the writ petitioner filed a complaint before the deputy commissioner. And deputy commissioner on 17/2/2023 have taken a decision on this complaint, lordship. And in the writ petition, nothing has been mentioned about the decision taken by the deputy commissioner and the complaint lodged by the writ petitioner. Why I'm submitting this lordship? The petitioner suppressed the material facts, approaching the court with unclean hand. Lordship, may kindly come to page 14. Lordship, may find whether it is a right translation or wrong translation. Page 14 up next.
Okay, will not do anything about it, but this paper publication at page 43.
That is the second amendment.
So this is paper publication. Whether this thing is properly translated or not translated in page 40.
Yes. Page 14, Lordship.
Page 44 of the writ petition. This is the paper publication.
Yes, this is correct.
It is correct.
Lordship.
It is correct. It is correct.
No, I am on the second imbued order, Lordship.
Which one?
Page 36, Lordship. This is also one of the imbued orders in the writ petition.
Okay. Since we'll not go into that aspect because
Lordship,
authoritative law has been pronounced in this judgment. This
that judgment
judgment,
has also been closed in the writ petition, Lordship.
that judgment, paragraph 89. The issue raised in this petition is whether such mode of punishment, that is excommunication,
Yes, Lordship.
will be permissible by any body or entity in purported exercise of enforcing customary laws. The answer of this court is in the negative in the light of the discussion above it.
That is settled, Lordship.
Settled.
Yes.
So,
Then
no
what about,
banishment,
Lordship, what
whatever.
about the settled law of the law laid on by the Supreme Court with
Huh?
regard to approaching the court with unclean hand and suppression of material facts?
What
That
the?
is also the settled law, Lordship.
What the?
Because, Lordship, the writ petitioner suppressed the material facts.
What facts?
Lordship, page 36, come to page 36. Against this order, Lordship, the writ petitioner filed a complaint to the deputy commissioner. And by page 44, Lordship, deputy commissioner taken a decision. Page 14, Lordship.
Page
Page 14. This is the scene taken under
40,
complaint.
40,
1-4.
1-4 of your affidavit.
Yes, Lordship.
What is this? What is this? What is this?
Lordship, may kindly come to Bharat 2. Representative of Chungja Village Council and Chungja Madam Sangapudu Mandan informed the house that the atmosphere in the village at that time of visit of the letter was not so conclusive to hold such a program in the village. That on 13/2/2023, one person was allegedly assaulted by the personal bodyguard of Shiri Chalukumba Ao, GDU candidate, and a complaint in that regard is under submission to the SP Moksha. Further, they said that the candidate presence in the village is during rivalry between the supporters of the two contesting candidates from Chundia, thereby reshading the baseball atmosphere of the village. Hence, on this ground, the Chundia Matamchanga Putumandan had requested T. Chalukumba our GDU candidate to leave the village for a while in order to restore normalcy in the village.
Even
This is the-
permanent or temporary? Nothing is permissible.
I'm not under law. Nothing has been mentioned in the writ petition about this order. This order was passed pursuant to the complaint lodged by the writ petitioner. I think it's
No, what did he pass?
This is the decision taken.
No,
And
you have
persons of
informed
both the
paragraph 2,
parties.
Mr. Jamil, hence on this ground, The Suntia Madam Sanger Putu Mandan had requested T. Chalukumba Ao JDU candidate to leave the village for a while in order to restore normalcy in the village. That
Next,
is
paragraph 3.
that he have given the explanation to the deputy commissioner.
Next, Lordship, next paragraph. Still C. And RO once again reiterated that every candidate has a right to organize any program in any part of the constituency if he has obtained due permission from the committed authority. Therefore, denying the permission to T. Chalukumba Ao to have the declaration program, that is his computer to which I have referred, would amount to denial of his fundamental rights guaranteed under the Constitution of India as well as under RBI Act 1951. However, he must also ensure that his activity within the village does not restrict or prohibit.
So from there, from this discussion, it clearly appears and emerges that deputy commissioner or whatever,
Yes.
SDO civil, returning officer,
Yes.
they don't have any, they have only advisory role. The power to quash an illegal order is vested in the court
True.
because they have not asked you to recall the order or they affirm the order. They are not the appellate authority.
Because this
Now 226 is maintainable against an order passed by a village council.
True, Lordship. True. What I meant is, Lordship, what I'm embracing this in this imbued order is, Lordship, against this imbued order, the writ petitioner, Lordship, complained to DC, and the deputy commissioner passed this order. However, in the entire writ petition, Lordship, nothing has been mentioned about the complaint lodged by the writ petitioner as well as the decision taken by the deputy commissioner.
Was he present there?
Yes, Lordship. Yes,
Lordship, I was not present.
no, it is mentioned in the minutes, Lordship. Is it not a suppression of material facts, Lordship?
No, I was not present. I was never invited, in fact. I have also stated that in my reply.
Background of the case, Lordship, may kindly.
Reply you have said you have not received anything.
No, I have not received.
You did not receive
I was not invited to be part of that meeting.
because copy two, it was addressed to you, but whether it was received by you.
That I have to seek instruction. Lordship. But I was not part of the meeting.
He
Lordship.
was not a part of the meeting.
I was never invited.
He was not a part. So show me that he was aware of it.
Only the private respondents attended the meeting.
You attended the meeting.
Yes, Lordship.
You explained the situation.
That is against the complaint lodged by the
Again, a
writ petitioner,
complaint, but
Lordship.
he was not present.
But then this you should mention in the writ petition about the complaint lodged.
It is there.
Roman 3, Lordship. In view of the worship, Thani Chalukumba has submitted petition to the deputy commissioner. And DU bring for bomb action against the leader of the Chundia Madam General Putumandan. Roman 3. Background of the case, Lordship.
When everything is illegal by you, the instant writ petition under Article 226 of the Constitution of India has been preferred by the writ petitioner.
Lordship, if I may, Lordship. Another prayer, Lordship. That in the writ petition. At page 18, Lordship. Issue a direction upon the respondent number 3, that is the deputy commissioner Mohocho, to initiate appropriate action against the respondents, that is the private respondents.
Mr.
Because Lordship, they have
Certiorari jurisdiction only takes the order. Make an allegation, complaint before the deputy commissioner after the order, but otherwise it can do not substitute in views. We test the legality and validity of an order. If it is found wrong, we set it aside. We do not travel beyond that. Did you make any complaint before the deputy commissioner? Did you make any complaint before the deputy commissioner against 5 to 18?
Lordship, that I will have to seek instruction. Lordship. But Lordship,
Yes.
in that case, Lordship, I kindly keep that group open for me. Lordship.
This is a collective decision, Mr. Council. It is, they are members. 5 to 18 are members, right? Members of the village council. Putu Menden, that is their collective decision, right? So when an order is passed, normally in other petition, because they were discharging their as a member of a statutory body, not in their individual capacity, and that was their collective decision. That order passed by respondent number 4, they were party to it as a member of the council.
Lordship, here, if I may be allowed to, Lordship, this case, Lordship, this kind of practice is very much prevalent amongst my tribe, Lordship. And
See,
Lordship,
Mr. Police stations are there, police personnel are there.
yes, Lordship.
That not to commit crime.
Now,
Not to commit crime,
yes, Lordship.
right? That IPC, Indian Penal Code, providing that
Yes,
murder, so and so. Basically, offense is not to be committed. Offense is not to be committed. Everybody commits it.
Now, if
That will not do, Mr.
if such actions are allowed
Then we'll
without,
defer, Mr. Then. Just
without any
because
repercussions,
we
Lordship.
we do not issue a blanket order. We do not issue any blanket order. For the welfare purpose, there is a different thing in PIL. But here lease is between you and the village council. Now litigation is against Mr. Council. The litigation is against between you and the village council. You are against the village council, against a particular order passed by the village council. Otherwise, they are entrusted with many other duties and functions. This they have passed purportedly beyond their jurisdiction.
Yes, Lordship.
And you have come here with,
And my fundamental rights have been
and
violated.
5 to 18.
Yes.
They were members of that village council and they took the collective decision which was reflected in Annexa 5. Am I clear? And also in Annexa 3. Temporarily they debarred, then permanently debarred for life. You have challenged this to her, and they are not individuals.
Yes.
They acted
Yes.
as a member of that village council.
Yes, Lordship.
If there is suppose respondent number 19, he also participated in the meeting. That is a different issue.
But Lordship, if such things are allowed to continue, Lordship,
We
without
do
any
not
fear of
pass any
repercussions,
blanket order, Mr. Council.
then
We do not pass any blanket order, futuristic order.
tomorrow,
Futuristic order we do not pass. Come up with an example that Supreme Court has ever passed. Futuristic order.
Lordship,
One
it will
cannot
not be a
prevent,
futuristic order,
one
Lordship.
cannot prevent by passing this kind of order.
Because fundamental rights of a citizen
Look,
cannot be violated,
henceforth,
Lordship,
don't pass any kind of order.
without any fear of repercussions, Lordship. Which is why, Lordship, the prayer,
That third prayer is, we'll deal with it. To a sale. two orders. Dash. Order dated 16 to 2023 and order dated 36 2023. Dash. Passed by the respondent number 4, comma, that is, comma, the Chungtia Village Council, comma, District Mokokchung. The petitioner has also prayed for a direction to the respondent number 4, comma, that is the Deputy Commissioner, comma, Mokokchung, to initiate appropriate action against the respondent number 5 to 18 as provided under the law. The respondent number 5 to 18 are members in the Chungtia Village Council, comma, that is the respondent number 4. Full stop. The by the order dated 16 to 2023, comma, the respondent number 4 had inter alia debarred the petitioner from being a part of Chungtia Village Council temporarily. On the ground that the petitioner did not act in the best interest of the village. Full stop. By the subsequent order dated 36 2023, comma, with the allegation that the petitioner had acted in contravention of the customary practices of the Chungtia village, comma, he was excommunicated from village, from Chungtia village, citizenship for a lifetime. Full stop. The order dated 36 2023, passed by the respondent number 4, was published in the daily newspaper, comma, daily vernacular newspaper. The daily Aunaga dialect newspaper. Any name? Huh? Newspaper name?
Yes. EIR. That is one word, and the second word is YIN. YIN.
TIR.
T for tiger.
TIR.
That is one. The first word, and the second word is YIN. YIN.
In its issue dated 2/7/2023. It is the petitioner. Petitioner has asserted that he is a native of Sunkia village and the district Mokokchang. Full stop. He was. Did you stood in the election? In order to stand in the election, stand in the election for the member of Legislative Assembly from 28 Koridang Assembly constituency in the general elections to the Nagaland Legislative Assembly held in the year 2023. He submitted his nomination papers and as a Janata Dal United candidate, right? But in the election, he did not emerge as the returned candidate. When the respondent number 4, Village Council did not extend. Petitioner was found himself aggrieved by the village action of the respondent of 4 Village Council when he was not extended the similar benefit like another candidate who stood against the petitioner in the same election. Held on 28/12/2023 election.
Two.
28/2. Though many other aspects are mentioned here, petition, the same are found not necessary to reflect to produce herein 7 except the relevant facts. The as mentioned above, the order dated 16/2/2023 was passed under the signatures of the members of the respondent number 4 Village Council. By the same order, the petitioner was informed that because of his alleged his alleged acts were not found in the best interest of Sunkia village, and therefore, the village council had taken a decision to debar the petitioner from being a part of Sunkia village temporarily. Full stop. By the subsequent order dated 36/2023, the petitioner was debarred and excommunicated from the citizenship of Sunkia village for his lifetime, and the petitioner was thereby informed that any household that would harbor or welcome him within Sunkia village would be locked. Full stop. The said order dated 36/2023 was uh, in the response number 5 to 18 had subscribed their signature, meaning thereby, the decision to excommunicate the petitioner by the response number 4 village council was a collective decision taken by the response number 4 to 5 to 18 as the members of the respondent number 4 village council. I have heard Mr. Senti Anger, learned counsel for the petitioner, Ms. Inaholi,
AIB.
AIME, learned senior government advocate, learned government advocate for the response number 1, 2, and 3, and Mr. Wati Jamir, learned counsel for the response number 4 to 18. Mr. Sentia Anger, learned counsel for the petitioner, has submitted that the response number 4, Chungkia Village Council is a statutory body under the Nagaland Village and Area Councils Act 1978, and its powers and duties are well laid down in the said act. It is his contention that a village council, like the response number 4 village council, does not have any power, authority, and jurisdiction to pass any order to excommunicate any inhabitant of the areas within such village council, either temporarily or permanent. Yes. Submitted that none of the two orders were passed after affording any kind of prior opportunity. And as such, to the petition, and as such, both the impugn orders were in clear violation of principles of nature. He has further referred to the decision of this court in Mangyang Lima versus State of Nagaland and others, reported in 2019, 1 ZLT 409, to submit that even taking shelter under customary lodge, a village council cannot pass any order of punishment of excommunication or banishment. Mr. M.S. Aimi, State Government Advocate, paying for response number 1 to 3, was submitted that since the requisition has been preferred, challenging the legality and validity of the orders dated so and so and the order dated so and so passed by the response number 4. The official respondents, that is the response number 1 to 3, had no role in passing of the said two orders. The legality and validity of the said two orders are required to be considered as per the in terms of the provisions, the provisions of the Nagaland Village and Area Councils Act 1970. Mr. Watijani, Nagaland Council appearing for the response number 4 to 18 has submitted that the two orders were collective decisions taken by all the members of the duly constituted Gauhati Village Council. He has further submitted that prior to passing of the order dated the first order. After passing of the order debarring the petition on 16 to 2023, the village council in a meeting on it was prior. Which one is prior? Meeting was prior or order was prior?
Order.
Order was prior. Had participated in had participated in a meeting with a subdivisional officer civil and returning officer, 28 Koridang Legislative Assembly constituency on 16 to 2023 and apprised the said authority about the backgrounds in which the order dated 16 to 2023 had to be passed. According to Mr. Jamir has further contended that it was certain actions on the part of the petitioner, which had resulted into a situation, not conducive to the for a peaceful situation to exist in the village council area, the impugned order had to be passed in order to maintain a peaceful situation in the village council area. So when the petitioner did not abide by the advisory issued by the village council during the subsequent period, the impugned order dated the council members unanimously and collectively taken the decision to debar the petitioner by the impugned order dated 36/2000. Yeah. But the land council for the I have given due consideration to the submissions advanced by the land council for the parties, and I have also gone through the materials on record, brought through the readings of the parties. I have also gone through the provisions of the Nagaland Village and Area Councils Act 1978 and the decision in Yang Lima Supra. Pera. As per the sorry, the Nagaland Village and Area Councils Act 1978 is an act for consolidating the law relating to constitution of village and area councils in Nagaland and to regulate their duties and functions and for matters connected therewith. As per Section 3 of the Act, every recognized village council shall have a village council. A village council shall consist of members chosen by villagers in accordance with the prevailing customary practices and usages, the same being approved by the state government, within bracket, as per section 4. As per section 6 within bracket A, every village council, unless otherwise dissolved by the state government, shall continue for 5 years from the date of appointment, provided that the said period may be extended by the state government by notification in a gazette for a period not exceeding 1 year at a time. And as per section 6B, all members shall hold office during the life of the village council. The second proviso to section 6 has provided that the village institutions which were traditionally established, Lordship, if I want to extend this particular proviso, it's like this also. The village council's tenure is only for 5 years, whereas in our areas, Kutumandan exists. So the lifespan of a Kutumandan varies from village to village. In some village, in my village, Lordship, it is 27 years. In another village, it is 20 years. In another village, it is 30 years. So they are saying that in light of the
as per the customs in which will.
That is why I'm mentioning it. Otherwise, I would not have mentioned it. Which were traditionally established like the Putu Menden, Putan, in our area, and recognized as village councils shall continue to function as village council according to respective custom and uses. So meaning thereby 5 years may not be there.
Yes, Lord.
That is what you indicated.
Yes.
Good stuff. The provisions contained in section 12 of the Act have outlined the powers and duties of a village council. For ready friends, come on, provisions of section 12. Reproduce hearing. Only up to 12, huh? 12, 12, not 13, huh? The as regards administration of justice command, the provisions contained in section 14 are applicable. Section 14 is fair. We'll resume at 2 then. We'll resume at 2 to dictate the other part. It will
May it please, my lord. Lordship, if I may be allowed to make a mention for hearing item 40 and 41, it is unlikely to reach the lordship. Therefore, if I have taken the consent of the council as well,
The prayer of Mr. Secretary, there is a council.
if it can be listed after 1 week, lordship. Lordship,
In the prayer of Mr. 41. Council for the petition. Let the case be listed. Mr.
Enangan.
Gamin Land State Council.
Right. And item 37, it is similar to the identical lordship to this item 5 and 6, which was posted on Monday, lordship, that's Tuesday, regarding that regularization case. So if we can be taken up together.
Tuesday. I think
37.
Lordship, I take to mention item 51, Your Lordship, and with the consent of the opposite party, with due permission, the matter may be fixed on 26th of March, Your Lordship.
26th of March.
Yes, Your Lordship.
Already 3 matters already fixed. Maybe some other than Mr. Yes.
Item 51, Your Lordship.
Yes, Mr. Jamir, you are there.
There's urgency, Lordship. 27 is division bench.
51, this one. Yes.
Yes, Your Lordship.
Your name, please, MS.
Your Lordship, Cricket. Your Lordship, Your Lordship, I would to mention item number 38. Let the matter come up after 2 weeks, Your Lordship.
Okay. Yes. Now,
AIM, Your Lordship.
claim Grand State Council, which raised me with the concern of the council for application. Is the case occur? Section 14. One. The respond number 4, Chunkia Menden Chenga Utu Menden is a village council which comes within the ambit of the second proviso. Second proviso? Second proviso to section 6 of the act. One of the issues which has come for consideration in Vanyam Pima Sutra was whether the village council, which comes within the ambit of the second proviso to section 6 of the act, is amenable to the jurisdiction under Article 226 of the Constitution of India. As the respondent of 4 hearing was have claimed what was the name of that council there?
In 2019 one, well,
Uh-huh.
Juimlang. Juimlang Village Council.
The same thing, like Putumen. Where it is mentioned. It is
Paragraph
Putumen.
4, first line, the very first sentence. It clearly tells them Putumen Sea as to plan after Juimlang.
Paragraph.
Paragraph 4.
The word Putumen is there. You said.
What should be paragraph 6, the last sentence? Use the word Ryong Samar Putumen. And then instead of using the name of the village, use the name of the
Paragraph.
paragraph 6. Last sentence.
Was a was similar, but it like the harassment of both hearing. Paragraph 26. It has been held therein that village institutions which were traditionally established like the Putu Menden in our area and recognized as village council shall continue to function as village council according to the respective customs and uses. So, and as such, and since Rule 6 of the Village Councils Act recognizes quote unquote Putu Menden in our area and also or our area also as village council under the act, comma, such body cannot deny coverage under Article 226 of the Constitution of India. The vaccine Mangian Lima Supra. Where that the Putu Menden involved therein had banished and excommunicated the petitioner from his own village for a period of 11 years with other restrictions. Full stop. The petitioner challenged the same such order of banishment and excommunication by preferring the petition. Full stop. The court, after analyzing the provisions of the Nagaland Village and Area Councils Act, 1978, more particular, the provisions of section 12 and section 14. As well as the provisions of the rules for the administration of justice and police in Nagaland 1937 as amended from 1990. Has concluded that the statutory laws do not recognize any form of punishment of excommunication or banishment, even for offences involving customary laws. Having regard to the issue involved in the said petition, that whether such mode of punishment will be permissible by anybody or entity in purported exercise of enforcing customary laws, the court in authoritative terms has held that no space body or entity in purported exercise of enforcing customary laws can impose any form of penalty of excommunication or banishment. By holding so, the impune order of excommunication and banishment, assailed therein, were set aside as void, being violative of the fundamental rights of the petitioner therein as guaranteed under Article 19 within bracket 1 within bracket D, Roman and E, and Article 21 of the Constitution of India. It has been further held that the petitioner to be entitled to remain in their village, in his village, and cannot be subject to social boycott, stroke expulsion from the village, as directed by the authority of Putumaiden, concerned Putumaiden. The fact situation obtaining the case in hand are similar to the one involved in Mangalima Supra. So the petitioner hearing by the impugned order dated
First one is dated 16/2/2023, and the second
by the impugned order dated 16 to 2023 was temporarily debarred from being a part of Sungtia village, and by the subsequent impugned order dated 36/2023, the petitioner has been debarred and excommunicated from the citizens of Suntia village for lifetime by the respondent Suntia Madam Sanger Putumenden as the respondent number 4, so and so Putu Sangen. Putu Menden is a body amenable to being a body, being a body amenable to the re-jurisdiction of the under Article 26 of the Constitution of India. The legality and validity of the impugned orders are definitely within the re-jurisdiction of this court. The power of judicial review under Article 226 of the Constitution of India to issue a writ in the nature of such a writ is available when a subordinate tribunal or a body, or when the subordinate tribunals or bodies or officers act wholly without jurisdiction, or in excess of it, or in violation of the principles of natural justice, or refuse to exercise a jurisdiction vested in them, or there is an error apparent on the face of the record, and such act, omission or error or excess has resulted in manifest injustice. Apart from as the respondent of court does not have the power, authority, and jurisdiction to pass an order in respect of a citizen to debar, to excommunicate and debar him either temporarily or permanently, the impugned orders dated so and so and impugned order dated so and so are found to be in excess of its power, authority, and jurisdiction, and the same are liable to be set aside and passed. Accordingly, moreover, the impugned orders were found to have been passed in clear violation of the principles of natural justice, as the petitioner was never afforded any opportunity to represent his case. In such view of the matter, or the orders impine her end, that is, the impine order dated so and so and the impine order dated so and so are set aside and passed. It is in granting a writ of certiorari, the High Court does not exercise the powers of an appellate tribunal, appellate authority. It does not review or review it does not review. It demolishes the order which it considers to be without authority, jurisdiction, power, authority, and jurisdiction, or palpably erroneous, but does not substitute its own views for those of the subordinate tribunals or bodies or officers found to have been acted without jurisdiction. It just by issuing a writ of certiorari, it puts out the offending order or proceeding out of the way as one which should not be used to the detriment of any citizen. As the response of 5 to 18 had issued the impugned orders as members of the respondent of full council in their official capacity, and the impugned orders were a decision taken collectively, the further relief sought in the writ petition as regards a direction to the Deputy Commission, respondent of 4, to initiate inquiry against the respondent of 5 to 18 are the court is not persuaded. Court is not persuaded to observe anything as regards the relief sought for by the petitioner to initiate. Relief sought for by the petitioner in the form of a direction to the respondent number 4, 3, to initiate. Please stop the commissioner. To initiate appropriate action against them as provided under the law. It is however made clear that such observation shall not, however, preclude the petitioner to resort to appropriate remedy if any, as permissible under the law.
For admission, item number 12.
Yes.
The petition is challenging the June letter, 15 November 2022. By this letter, the petitioners prayer for
Page
109, annexure 30.
Yes, नीचे भी आसुमी
Yes, Lordship. Lordship, then Mishivi or Sumi. Lordship, this is a case of,
What is your case?
Lordship, my case is like this.
Let us see your synopsis first.
Yes, Lordship.
Where is the notification dated 14/11/2012?
Page number 72. Right?
You died in harness as what? The petitioner's husband?
Sweeper.
Sweeper.
That's it. Yes.
Sweeper.
But these are in Cs. Since the sweeper comes under the in C category.
C?
In CE, non-combatants employees.
NCE.
In CE.
NCE. Non-combatant
Non-combatant employees.
Huh?
Employee.
Employee. So meaning never pay 72 annexer C. Those are NCE.
The list of NCE is at page
No,
number 75.
that is regarding NCE, annexer C.
Page 75.
Okay, sweepers were there.
By this
1 minute,
notification,
1 minute.
this is, you should incomplete the order passed by this rule. You should test the government that they have issued this notification dated 14 November 2020.
Where is that face manner order? Face manner.
For should the statement made by the state respondent to regardless in face manner.
That they would regularize
In face manner.
417 numbers of employees in phased manner.
That is a statement made by the state respondent in India before this rule.
Okay, is it part of the record?
Yes, sir. Page number 53.
Page number 53. Which paragraph?
Paragraph number 57, Paramount. By taking into consideration the statement made, this move for disposal of petition by order dated 17/11/2009. That is at page number 59.
You were a member of that
I was a member of that, my husband.
husband. And where is the, that you said that similarly situated
Yes, Lordship.
WBC 129 of 2019.
Page 79.
When appeal repetition 250, it is 250. You want to say that you are similarly situated like the petitioner in WBC 129 2008. Yes, madam.
At that point of time. The legal position is your lordship, that we should be cases.
Dice aquí, ahorita dice que ya.
Yes.
I remember correctly, during my last visit, I read that there the person died, and during his died after on superannuation, right?
In that case,
The-
yes,
That superannuation, that man, Iseki Asumi, in that case, the person died in harness or superannuation? Harness. And that man, before his death, he did not make any claim for regularization. Then he expired. Then few years lapsed. Then wife came in a petition. It was in that context the judgment was delivered. Here, it was in 2009. State has made a representation before the court that 417 persons will not be possible to regularize at one go. They will be regularized in phase manner. So there is some kind of assurance given to the petitioner's husband that he will be regularized. But one cannot predict date. It can come suddenly also. This moment you are here, next moment you die. So this is an unpredictable event. But at that point of time, he was with the assurance that his service will be regularized. Unlike in Nisevia Arjun. So this is the vital distinction.
yes, sir.
And that WBC 129 2009 was almost in similar circumstances.
19.
19. That was also almost in similar circumstances. So why not the petitioner?
Then is declaration later.
Ah. Third, Mr. Wapang, Learning Council for the petition. MSS Mary, Lawrence New Bullet, Nagaland, for all the respondents. The petitioner was the wife of one late Chuli Yangami. The case projected in this petition can be, in brief, narrated as per, can be exposited as follows. While an order dated 1/8/1995, correct me if I'm wrong, 1/8/1995, comma, the superintendent of police, within bracket, wireless, bracket close, comma, Kohima, Nagaland, appointed the petitioners, appointed, appointed, so and so. As sweeper, rupees 23. In the pay scale of rupees 800 less rupees 1475 per month plus all other allowances from time to time. WEF 1/8/1995 against an existing vacancy, right? Full stop. As per the order dated 1/8/1995, the appointment was on an ad hoc basis and be terminated with 1 month notice if his performance was found not satisfactory. By the same order, so and so Hangami was posted at 1st NAP Battalion, Shumuke Dima till further order. While so and so was in active service, the Inspector General of Police within Crime, Nagaland served a show cause notice dated 27/11/2021 to 462 number of employees, including so and so Angami. The petitioner's husband, that is, so and so Angami, was a member of the Nagaland Police Wireless Association, aggrieved by the show cause notice that is 27/11/2001, the Nagaland Police Wireless Association taking up the cause of the notices, preferred a writ petition, WBC number 221 within bracket K stroke 2001, challenging the show cause notice dated 27/11/2001. The writ petition, WBC number 221 K 2001 was, however, dismissed by a judgment and order dated 12/8/2003. Aggrieved by and dissatisfied with the judgment and order dated 12/8/2023, the petitioner, the Nagaland Police Wireless Association carried the matter by way of an intra-court appeal, read appeal number 371 stroke 2003. Para, subtitle. Where it was that affidavit was filed? 221? No. In some other petition. Okay, okay. During the pendency of the writ appeal, WA number 371 stroke 2003, the state, the department, the home department, the department of home decided to conduct fresh recruitment test. Agreed by such decision of the department to hold fresh recruitment test, the Nagaland Police Wireless Association had again preferred a writ petition, WBC number 763 stroke 2005 within bracket, renumbered later on as WPC number 250 stroke 2006. bracket close. Close. The state respondents filed an affidavit in the writ petition, WPC number 250 within bracket K stroke 2007. Taking a stand that the members of the Petitioners Association, taking a stand that the number of members of the Petitioner Association were 470. And their and the regularization of such 417 members at one go would be burdensome for the state respondents. A stand was taken to the effect that regularization could be considered only in phase manner. Fair. On 17/11/2009, both the writ appeal, writ appeal number 371. I'm sorry, 1 minute.
371 was remembered.
The writ petition, WPC number 250 K stroke 2006. And a writ appeal, writ appeal number 15 within bracket K stroke 2007 came up for consideration, right? And what was that writ appeal? Otherwise, you were involved there.
Yes, Roshit. The first writ petition was dismissed. That were filed in the personal page. That was numbered as WPC 371. After transferring here,
Writ appeal number 371 of Silan. Begin bracket. Later on, renumbered as writ appeal number 15 within bracket K stroke 2007. On 17/11/2009. The repetition WPC number 250K stroke 2006 and writ appeal number 15K 2007 came up for consideration. The repetition from WBC number 250K 2006 was disposed of with a direction that the state respondents shall proceed in a manner indicated in as per the stand taken in the affidavit in opposition filed on 2/3/2009 therein, meaning thereby, full stop. The it stands. It needs reiteration that in the said affidavit in opposition, the state respondents had taken a stand that the regularization of the members of the petitioner association, 417 in number, could only be taken up in phased manner. Full stop. In view of the order passed on that day, that is, 17/11/2009 in the petition on WPC number 250K 2006, the repetition, writ appeal, writ appeal number 2007 was not pressed and accordingly, the same stood accordingly disposed, right? As the petitioner's husband, so and so was the disposal of the repetition WPC number so and so in the aforementioned manner on 17/11/2009, the petitioner's husband was under legitimate expectation that his services would be regularized in due course. Full stop. Unfortunately, so and so Angami died in harness on 17/6/2011. Full stop. It was after the death of so and so Angami, who is those annexers? The state, the Home Department, government of Nagaland issued a notification dated 14/11/2012 pursuant to in which was in compliance of the order dated 17/11/2009 passed in the writ petition WPC number 250K 2006 and orders and in the writ appeal, writ appeal number 15K 2007. By the said notification, the state government regularized the services of 357, right? 129 316. 357 number of excess appointees in the Nagaland Police Telecommunication Organization WEF 16/2012 as per details furnished therein. Where annexer A thereto, 9 number of employees, services of 9 number of employees were regularized in the post of Havildars within brackets signal. Whereas by annexer B thereto, the services of 316 number of employees were regularized in the post of constable in brackets signal. In addition, 32 number of employees, services of 32 number of employees were regularized, provide annexer C thereto in the post of non-combatant employee within brackets signal. There. The petitioner has instituted the present writ petition seeking inter alia direction in the nature of mandamus as to why in the nature of mandamus to after the demise of Chuangami on 17/6/2011, the petitioner approached the respondent authorities with a prayer to regularize the services of her deceased husband, Angami, so as to enable her to avail family pension. At first, the respondent number 2 that is the Principal Secretary, Personnel and Administrative Reforms Department, examined the claim and requested the respondent number 3 request the Home Commissioner, Nagaland, to identify a vacant sanction post to regularize the services of her deceased petitioner's deceased husband. Where can I find that?
Page 99.
Reform Commissioner, to the respond number 3, comma, that is the Director General of Police, comma, right, his communication number so and so dated 17/8/2022, page 99. Poster. The no. Close it.
Page number 100. You have indicated within the vacancy.
The matter of posthumous regularization of the services of the petitioner's husband and of another person after the demise question, the respondent authorities were the matter of regularization of personnel who expired during the period of the judgment rendered by this court on 17/11/2009 and the notification dated 14/11/2012 came up for consideration, were considered by the respondent authorities. It was, and after consideration, it was found that eight out of 417 expired during the said period before regularization of their services. Mr. So-and-so Angami was one of such 8 personnel who expired prior to issuance of the notification dated 14/11/2012. The case for regularization of the services of so and so Angami posthumously was considered by the Personnel and Administrative Reforms Department, and after examination, the Personnel and Administrative Reforms Department on 18 had requested the Home Department to identify a vacant sanction post against which posthumous regularization of so and so Angami could be facilitated. To stop. Accordingly, the Home Department, Government of Nagaland, wrote to the Director General of Police, Nagaland, via its communication number, page 99, dated 17/8/2022, to take further necessary action. To stop. On 109 is the impin order. On 15/11/2022, the Home Department, Government of Nagaland, by its later number so and so 109, dated 15/11/2022, conveyed to the respondent number 3, that is the Director General of Police, Nagaland, to the effect that after examination of the matter of posthumous regularization of so and so Angami, it was found that it would not be possible to regularize the services of so and so Angami posthumously in view of the Supreme Court judgment in civil appeal number 4223/2022, within bracket the state of Nagaland and others versus Nisevi Achumi, bracket close, decided on 11/7/2022, and in WBC number 232/2006, within bracket Ekta Shakti Foundation versus Government of NCT of Delhi, bracket close, decided on 17/7/2006. What is this Ekta Shakti?
Ekta Shakti is any order obtained on one person that cannot be applied in another case.
Do you have the copy? Agreed by the rejection of the case of posthumous regularization of so and so Angami by the communication dated 15/11/2022. The petition has approached this court by the instant petition. Para. Mr. Lipa Wapang, counsel for the petition, has submitted that the facts and circumstances in the case of Nisevi Achumi are different from the facts and circumstances in the present case. The deceased husband of the respondent in civil appeal number 4223/2022, Nisevi Asumi was working as work charge Jugali, who died in harness on 28/8/2005. Full stop. It was in the year 2017, that is after elapse of a period of 12 years from the date of her husband, the respondent widow preferred a repetition before the High Court, claiming that the services of her late husband ought to have been regularized, and therefore, she could be entitled to the family pension. The repetition was allowed, directing the appellants, directing the state to regularize the services from one day prior to the date of his demise. Full stop. When the state preferred an appeal, read appeal before the division bench, the division bench by a judgment and order 19/4/2021 passed in read appeal number 21 of 2018, dismissed the read appeal. Full stop. When the state preferred the civil appeal number 423/2000, the same was allowed observing that same was allowed, and the original repetition was dismissed. Circumstances it is his submission that the there was uh, the state respondent in the writ petition WPC number 250K 2006 had taken a stand that the members of the petitioner association, Nagaland, Wireless Association, numbering 417, services of all the members of the petitioner association, Wireless Association, numbering 417, would not be regularized at one go, but their cases would be considered in phase manner. As such, there was an assurance that assurance from the state respondents that the services of the petitioner's husband will be regularized in phase manner. He has referred to an order dated with judgment and order dated 12/10/2020. See, thank you versus the state of rendered in a writ petition WPC number 129 of 2019, Private Packet. In a similar case, the petitioner therein was a widow of a deceased employee in the deceased employee like the petitioner's husband, and and the said employee expired without his services being regularized. Para MS Miri, senior government advocate appearing for all the respondents, has submitted that the case of the petitioner's husband for posthumous regularization cannot be considered in view of the decision rendered by the Honorable Supreme Court of India in Nisevi Achumi Chupra. Drawing, MS Mere has sought to draw similarity with the case of the case of the petitioner with that of Nichevi Azumi. It is submitted that the petitioner's husband died prior to issuance of the notification dated 14/11/2022. I have duly considered the submissions of the parties. Also have gone through the actions brought by the parties to the case. Gone through the decision of the Supreme Court of India in Nichevi Azumi Supra and Acta Sukti Foundation the facts till the events which have led the petition to institute the petition have already been adverted to in the preceding paragraphs. So there is no dispute to the fact that the petitioner's petitioner's husband, so and so Angam, was one of the members of Nagaland Police Wireless Employees Association, which preferred the petition WBC number 250K/2006, and the said fact was also admitted by the state respondents in the affidavit filed in the petition WBC number 250K/2006. The stance taken by the state respondents in WBC number 250 in the counter affidavit before the court in WPK 2000 to WP 250K 2006, that the matter of regularization of 417 number of members of the Nagaland Police Wireless Employees Association to be considered in fierce manner is also admitted. Is also an admitted fact. After the disposal of the writ petition, WP 250K6 on 17/11/2019, the state government the matter of regulation of matter was under consideration of the state government during the subsequent period. So we just, in view of such stand of the state government's there was clearly a legitimate expectation on the part of those 417 number of employees, including that of the petitioner's husband, that their services would be regularized in due course of time. Unfortunately, so and so expired on 17/6. When the matter of regulation of his services were under consideration of the state respondents. It was only on 14/11/2012 the state respondents finalized the matter of regulation of services of 357 number of employees out of 417 surveying out of 417. Thus, the facts and circumstances obtaining in the case in hand cannot be said to be similar to the case in Nichevia. The petitioner in WBC number in a repetition, WBC 129 2019 was a widow of one late L. Imtilong Jamir, who was appointed as a constable in the Nagaland Police Queen Bracket Wireless on ad hoc basis with pay and allowances. WF 1999. L. Imtilong Jamir expired before his services could be regularized. Full stop. The Korean bench took note of the orders passed in WBC number 250K 2006 and WA number 15K stroke 2007 and the stand taken by the state respondents in paragraph 6, 7, 8 and 9 of the affidavit in opposition of the affidavit filed in WBC number 250K stroke 2006. After taking note of the same, the repetition was disposed of by the order dated by the judgment and order dated 12/10/2020 with a direction to regularize the services of the petitioner's late husband for the purpose of pensionary benefits, including the family pension. With the following observations is 86. The decision in Ekta Shakti Foundation was delivered in a public interest litigation in a matter of in a matter relating to implementation of the integrated child development service ICDS program. Which part they are saying? They are not mentioning anything. In the impugn order, they are not mentioning anything. What principle is laid down here?
One of the impugn letter at page 101, your definition. No decline because
101.
101. The second paragraph. The second paragraph in the third last line.
101.
In the second paragraph in the third last line. The judgment order also cites that this loan touch of the foundation was governed of institution, which establishes that a loan judgment in favor of one person does not entitle
From the communication dated communication bearing number so and so 10 dated 19/9/2022 of the Personnel and Administrative Reforms Department, Government of Nagaland, it can be discerned that the ratio in Ekta Shakti Foundation Supra to the effect that a wrong judgment in favor of one person would not entitle any other person to claim benefit on the basis of the wrong decision has been sought to be invoked by the state respondents, sought to be applied by the state respondents. The decision is so decision is what it decides. I took mine. In view of the discussion made and for the reasons mentioned here. Where is the MP order? The decision, the impugned decision contained in the communication bearing number so and so, page 109, dated 15/11/2022 is found not sustainable in law.
Piece number 114. Piece number 114.
114.
By this date of it, we are affirming the earlier.
114.
114. After 109, the petitioner submitted a resolution. I think that was also rejected by 114.
And what do you say? Okay, impugned later. Example, 15/11/2022 arrow 6/2003 6/2000. Yes, sir. After the in the communication bearing number so and so dated 15/11/2022. By the state government in the home department had conveyed that posthumous regulation of the services of so and so Angami could not be made in view of the decision in Nichevi Achumi Supra and Ekasoti Foundation. To stop minute. Petitioner submitted a representation against the communication dated 15/11/2022, comma, the impugn order hearing number so and so dated 6/2/2023 is 114. Has been passed by the respondent number 3, comma, Director General Police. First. In the said impugn order also, comma, the decisions in Nichevi Asumi Sutra and Trust of the Foundation Sutra were referred to reach a finding that the case of the present petition was covered by the said decisions. As in the discussion made above, this court has reached a view that neither the decision in Nichevi Asumi Sutra nor the decision in Acta Sakti Foundation Sutra is found applicable to the case of the petitioner, the case of so-and-so Angami. Full stop. It is reiterated that in Nichevi Asumi Sutra, the disease, there was no case, the case of the diseased husband of the petitioner was never considered for regularization, whereas the case in hand, it was the state respondents themselves who had given the undertaking that, who had made the undertaking before the court that the case of the petition, case of so-and-so Angami would be considered in phase manner, and towards implementation of such decision for regularization, the state respondents had regularized the services of 357 number of employees of Nagaland Police Wireless Organization on 14/11/2022, merely because the husband of the petition, so-and-so Angami, expired before he could enjoy the benefit of regularization, such benefit could not have been denied. It is not permissible on the part of the state respondents deny such benefits by taking resort to Nichevi Asumi Sutra. Side view of the matter, the impugn orders so-and-so dated so-and-so and so-and-so dated so-and-so are set aside and passed to stop with the observation that the respondents, no, with the direction that the state respondents shall take necessary steps to regularize the services of the petitioner's late husband so-and-so Angami for the purpose of pensionary benefits, including family pension, So the entire exercise shall be undertaken and completed within a period of 3 months from the date of receipt of a certified copy of this order at the office of the respondent number 3. The petition stands allowed to the extent in the there shall, however, be no order as to cost.
For admission, item numbers 14 to 16.
Mr. Jamil, then your case. What to do? Depends. Okay, 14.
Lordship can keep it part heard. So that
I'm not giving it part, but Monday I can fix.
Lordship.
Time permits. I'll take it.
Monday is a holiday.
Or Tuesday.
Tuesday.
We'll try. Give it a try.
Lordship.
That is the best we can do.
Lordship.
Now, see, is there this morning someone mentioned that? Yes, Mr. Council. Prayer was made for adjournment and you.
Yes, Lordship. Lordship, there are 5 linked matters. Item number 49 and 50 also is linked with the present 3 petitions, Lordship.
14, 15, 16.
49 and 50, Lordship.
14, 15, 16 and
49 and 50.
okay.
So,
Yes.
Lordship,
What to do? I don't know. Subject to he has 5 matters before you. He has 5 petitions.
Tomorrow.
No. He has 5 petitions.
Yes.
Right now.
Lordship,
I'm not praying for right now, but if we can be, I can be accommodated
Tomorrow, because
18.
yes, I know, but tomorrow this court has some difficulty because I have to reach Gauhati to attend, to preside over a tribunal on Saturday. Saturday. Though it is holiday, I have to attend. It is a tribunal of Tripura. And that matter has been assigned to this school as I am presiding officer of that tribunal. Unlawful activities, extremist organizations related to that. We can, what is the subject matter?
The matter is, I applied for a reference to the connector, reference to the port. My application was dismissed on the ground that civil suit is pending. This is the only thing.
Tomorrow, Mr. Yal, it is not possible. Maybe
After this item,
it's difficult. 5 items. You are seeking disposal or what?
I'm seeking for disposal, Lordship. since it is a
Disposal.
regularization.
Then it will take time, Mr. Then maybe 1st of April.
but,
Tuesday date, I can fix that. Due to paucity of time, that is could not be taken up today. So stuff as sought for by Mr. Ariyalu as the petitioner. The case will be listed on. Yes. Why you are seeking this?
Yes, in all the 5 petitions, Lordship, the petitioners are seeking for regularization on the basis of the scheme. And all the petitioners are enjoying scale of pay. Plus, they have served for more than 30 years, and most of them have served for 34 years and on the verge of regularization, Lordship.
Affidavit is filed.
Affidavit not filed, Lordships.
Then
But Lordships, since they are squarely covered by the office
no,
memorandum.
unless
and
because otherwise, if the stand of the respondent is not there before the court, then it is a very good ground for preferring a writ appeal.
That is also their Lordships.
I do not want to leave that scope.
My apprehension is that, my lord, while waiting for instructions, they have been seeking time to take instructions, and this honorable court has also directed them in the motion stage itself to get instructions, oral instructions, as to the status of my representation. And till date, no instructions has come forward, Lordships. So that is my apprehension, Lordship. And Lordship, for the petitioner in WBC number 286, 287, and 289, it has become, this petition has become infructuous because of the fact that during the pendency, they have regularized my petitioner in WBC 286.
You can close those.
Yes, Lordship. That's infructuous.
Item number?
Item number 15, 16, and item number 50, Lordship.
286, Locheno Lotha.
Yes, Lordship.
Okay. Then
287.
287.
287.
287.
Even then, Lordship.
287. One is 286.
One is 287.
One is 287.
And the third one is 289.
289.
I may be about to place the.
Okay. Otherwise, if things are misplaced somewhere, it is got enclosed in another file.
Yes,
that is disposed of.
Yes,
it will be difficult. Lochemo is 286. 286.
Yes,
Lochemo is 286.
Yes, Lochemo is 286.
Renmeni
289.
287.
No, 289.
Huh? No. What? No. 87.
Renmeni will be 287. 289.
Locheno is no dispute.
Yes.
Okay, then one is Ubeno. It is 289. 289. Ubeno is 289. It is there. Okay. Regularized. Third one is Renmeni. That is 287.
Yes,
correct?
Yes, correct.
Six. No state council. MS. Heard Mr. Toshi O. Longkumar. Item 286. Item 286 means Toshi O. Longkumar Learning Council for the petition and MS. No, he's closing this petition. There no harm will be caused to you. And so and so, learned government for the state respondents. Mr. Longkumar has learned council for a petition has submitted that by an office order bearing number bearing number so and so dated 21/2/2024, the services of the petitioner Lochemo has been regularized as R/stroke sweeper against a post created by cabinet approval dated 21/3/2024 by placing a copy of the said office order dated 21/2/2024. Mr. Longkumar has submitted that since the petitioner has got the relief during the pendency of the writ petition, there is no necessity to proceed further with the writ petition. In view of the above submission made by Mr. Longkumar and counsel for the petitioner, the writ petition stands closed, so stop. A copy of the office order dated so and so, comma, placed by Mr. Longkumar, comma, is to be kept with the case record. So, yes, sir. Then same office order date same, e-revenue was created against so and so, cabinet approval dated so and so. Everything same. Ubeno. Ubeno. Same. Okay, what are the remaining two?
285.
14. And 50. 285 দিব 285 দিব ঠিক আছে আৰু 288
Lordship, my prayer is that since all of them are similarly situated, Lordship, 3 of them has already been regularized, why not the petition?
okay, I'll put that thing that the similarly situated persons, the petitioners in so and so have already been regularized.
Yes, Lordship.
State council shall obtain instruction
Yes.
as to whether the case are considered or not.
Yes.
Instruction. That will do.
Yes, that direction can be given, Lordship.
I just you take the instruction.
Yes, sir, but Ithiba Holmes name be reflected because he's handling this matter.
Heard Mr. Toshi O. Longkumar, WBC 285. Counsel for the petitioner and MS so and so landed government advocate on behalf of Mr. E. Thibapong, learned government advocate for the respondents. The Mr. Longkumar, learned counsel for the petitioner, has submitted that 3 of the similarly situated read petitioners, that is the petitioners in WBC number 287, WBC number 286, WBC number 286
and 289.
286, 289 and 287. এইকেইটা না কোনকেইটা এই যিকেইটা অৰ্ডাৰ দেখিলে না have got the reliefs in the form of regularization, during the pendency of their petitions, which were filed at the same point of time. Full stop. As the state respondents has not placed any instruction as regards any decision regarding regularization of the services of the petitioner in the case in hand, government advocate shall obtain instruction as to whether the case of this petitioner has been considered in similar manner like the petitioners in WBC number 286, 287, 289. So and so has sought for listing of the case on 15/4. 2024 to place the instruction by the government. Same in item 288. Same one. Yes.
Obliged, Lordship.
Yes, Mr. Joe. You're waiting for something. Oh, somebody 27. You mentioned something in the morning. That cannot be done in pension time.
My apologies. Your Lordship, I may be allowed to take steps upon the respondent number 7 by way of substituted notice. Your Lordship.
Third, MS,
B today.
B Terry,
Yes.
B and A Terry, and counsel for the petition. Close the. As in view of the office note dated 14/2024. The office note dated 14/2024 has reported that notice issued to the respondent number 7 has not yet been returned. In view of such situation, MS Terry, counsel for the petition has submitted that the petitioner may be permitted to serve a notice upon the respondent number 7
Yes, Your Lordship.
in the substituted manner by way of paper publication.
Yes, Your Lordship.
The publication was ready, it should be in a
Yes.
1 or 2.
Your Lordship, 2.
2.
Yes.
What is the address of the respondent number 7?
This is the resident of Umma village, Mahopjuna.
Having wide circulation
Yes.
in the district of Mokokchung,
Yes.
including newspapers.
Yes.
Okay. Date of hearing,
Your Lordship, it may be fixed on 2nd of April, Your Lordship.
how can it be?
The date may be
If
fixed. Your
if the
Lordship.
paper publication is made, one date should be given. That should be at least 1 month.
Your Lordship, here in this case.
Why you are in a hurry?
Your Lordship, because the petitioner is going to become overage, Your Lordship. Yeah, she's going to become an overage, Your Lordship, to be employed in government service. Your Lordship.
Because one date of hearing is to be fixed, right? In a newspaper publication, one date of hearing is to be indicated,
Yes, Your Lordship.
right?
Yes.
Then, if she does not come, then 1 month has to elapse to treat as deemed service. So it should be within a period of 2 weeks, you publish it.
Yes.
That
Then a date may be.
on or before
8 of April, Your Lordship.
8th of April,
Yes.
you publish, indicating the date of hearing of the repetition as the next date of hearing, 29.
Your Lordship. 15th, Your Lordship. 15th of April, Your Lordship.
April.
Yes, Your Lordship.
No, if you publish the newspaper, the date of hearing is to be given.
Yes.
And that one should have the appropriate time to appear, engage, the counsel. You know,
Yes, Your Lordship. These 2 weeks.
if you come, suppose it was published on 8, that respondent may not be in a position to come and appear before the court on 15. Reasonable time should be given, madam.
Paper publication will be done next week, Your Lordship. The paper publication.
Okay, on or before 5th of April.
Yes.
Publication. Indicating the date of hearing as 22nd.
Right.
Yes, Mr. Seki. Yesterday, because one of the journalist contention was that registered post. That I recorded, but last part, because of lack of time, you know, So we'll leave it to the respondents, that part.
My lord,
I'll not decide.
your lordship, your lordship,
Just an observation.
my lord,
As regards the two,
my lord. Yes,
out
your
of
lord.
four, we are not considering about two because they were not applicants for those posts.
Yes,
The
lordship.
remaining two, about whose qualification, we did not decide. But that aspect was contended, that it has to be by registered post. That will leave it to the
My lord, your
government,
lordship, your
government
lordship,
to check.
my lord,
And thereafter, it is found okay, issue appointments,
my lord,
right?
lordship.
Yes, Mr. Joe,
My lord, I think 44 to 48 is analogous.
can't help it.
That these petitioners are challenging the suspension order issued by the government.
Suspension order,
Suspension. They are all regular government
regular employees.
Yes, and also the defendants of the criminal case, they have been suspended. They are under suspension for almost about 5 years.
5 years.
Yes, so that's good. I know the time situation now. So
Now, have you, I think criminal case under what provision, what section? What charge? Corruption,
no,
IPC?
yes.
Huh?
One the
Review? No review,
no,
no review.
nothing at all. For the last 5 years, no review of suspension. That is the ground.
Affidavit file.
If they short,
Right. Or still it takes time.
my lord,
Point may be short. Affidavit file.
yes, yes.
I think this court, division bench, authored by me with Justice Sarto, I think we passed an order.
I have.
Huh?
My
DB matter. State came in appeal.
lord,
That matter relates to suspension and regarding criminal charge.
similar. SB allowed my petition. The state filed before
You were the respondent there.
I'm the petition. That also I'm.
Now, in the appeal, you were respondent.
Yes. State filed.
Exactly covered or distinct fact? Exactly covered case or
Exactly. Same, more or less same. That's what I would say.
Mr. You go through it?
Yes, I've gone through it. And even the last year, I think sometime the same. That's also to the end of the court session last year. I want to bring one larger bench judgment, and that's we call RP Kapoor.
RP Kapoor,
Yes.
19 something.
1963.
Huh.
For academic, even the second academic.
That's simple. The principle later is very simple. Paragraph 7 is 11. Then the principle laid down by the Supreme Court in 1966 is that whether the suspension can be treated as punishment or
Suspension cannot take the form of punishment.
Yes.
Prolonged suspension is punishment.
It's more than that. It's more than that. It is.
Huh?
In the
You will
judgment,
be
it's-
relying on RP Kapoor.
yes.
Huh? You'll be relying on RP Kapoor. I think then you relied on last time also.
Yes, yes.
These cases.
Yes.
Same case, same case.
These cases.
Yes, same case.
We could not take up like this.
Tomorrow we'll just examine because I have to leave early. Okay.
Tuesday.
No, tomorrow we'll just examine.
Lordship, no, Lordship, I beg your, I have already a fixed material for tomorrow.
No, I'm saying that I'm not disposing of. We'll just examine.
Lordship, but I've already have a fixed item.
No, I'll go through the files only. I'll not pass any. If I find similarity and I find your point really regarding RP Kapoor to be taken note of, we'll just observe. We'll not pass any order tomorrow. Be sure about that.
The thing is whether I could be, when the matter is called, I don't know whether. I could be
Then
there.
we'll differ. It is very short distance. From there to there, hardly 25 steps. Right? We have many, hardly few matters tomorrow. We'll just see. We may not dispose of. And if you are not available, we'll defer. With that understanding. Okay? No, I'll not do that. It should be but before 12 o'clock. We will make an attempt. At least there are cases tomorrow. We'll make an attempt, but I will not assure anything.
Also could not be taken up on many occasions.
What to do, Mr. Seti?
I heard several matters have been fixed on 26, but if this matter can also be tagged along on 26, Your Lordship.
Hey, try your luck. Try your luck. 26.
My Lord, on 26.
26.
Unless my Lord gives some direction whether it will be listed on 26 or not.
I'll list on this.
My Lord. Bless you, Lordship.